Hello.
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 Hello, guys.
All rise and like, subscribe, and bang the gavel, baby.
Gavel is we got that. We're good. We're here. We're live. My internet, the storms, my God. Wind, crazy rain.
Crazy rain.
So good. Please make sure to like this if you're new here. Subscribe, notifications on. We got a case 5 days a week, 1 o'clock start. Got a couple hours for you. Listen, I want to start with something. We got some good first appearances happening down there, but I want to start. I want to start here. I was with these guys till like 7 o'clock last night. We were on this for like 2 seconds yesterday. And
we made a mistake and left is what you're saying.
What I saw last night was pretty crazy. I'm just going to give you a few things. The two at the end, Sarah and Steven, ex-wife, ex-husband. Some crazy stuff was happening yesterday. We're going to start here. We'll see how things are going. And we'll go from there, if that's cool.
Let's do it.
All right. As always, we're going to try and speak as little as possible. Anything else we need to say? Or are we good?
No, let's do it.
All right. And hi, everybody.
Hello.
Your Honor, I'm sorry. I should have said this earlier. We have just one witness, and that's Miss Maya Touchstone, who I would like to examine 5 or 10 minutes. I'm not going to spend much time. She is in a surgery and will be available, I believe, at 3 o'clock if I can take her quickly at that time.
Wow.
Oh, boy, very upfront. Wants to take her.
Wants to take her.
I think that's probably going to be fine. That presumes that you'll have time left when we by then. But I think we'll just see you back at 1:30 and see.
So we have an hour total. We only have an hour total between us.
Perfect timing.
A little over an hour.
That's what it looks like. But obviously, I'm going to allow the guardian to answer any and all questions that the court may have and allow you both time.
Did you say the wife is like really like important, like a doctor or something?
And in the meantime,
from what I understand, I think that she's a plastic surgeon.
He looks like he collects Funkos.
Yeah, I do look that way. All right, well, we'll have to watch. What a great start! Yesterday was pretty crazy. He has been living off of mom's money since they broke up, which was pretty funny questioning yesterday. Anyways, over to first appearances. We'll keep an eye on that if they come back later. But then again, if they're going to be questioning,
work at a minimum of 8 hours a month in the Bay County Work Program, I will give the Florida.
So they're going to talk to the guardian.
Amend that direction of the probation officer. If he's required to give a DNA sample,
Florida, by the way, if anybody's wondering,
he's to have no contact with Derek Roberts.
It's a guy that just keeps seeing different counties, right? Jumps right through them.
You have 30 days to file your notice of
so far, he's only been right here.
If you'd like to have an attorney to represent you, you can't afford one. One may be appointed to represent you, no charge. Good luck to you, sir. You step over, your fingerprinting, and speak with the probation officer.
Get the hell on out of my way.
Who's next?
Next.
Who wants some of this? Good to see you.
Worked for a plastic surgeon. Okay.
Oh, okay.
21, 42, 30.
That's a whole different ballgame.
Real close to resolution.
Yeah,
I guess we'll go on May if we resolve
it was very interesting. I hate that they just went to break.
Move him up.
Good question. I don't know. I'll be honest with you. If we caught that in the beginning, I would have watched it all the way through from what I saw yesterday.
Look, they're fingerprinting them over there.
Gibbons?
That's unusual.
Yeah, that's different.
Your Honor, this is Zachary Gibbons in cases 21, 44, 26, 20-872, and 21-1356. At this time, Mr. Gibbons would enter plea of guilty to one count of causing a minor to become dependent, which is a lesser included charge in case 21-4426.
What?
First degree misdemeanor, punished by 1 year in Bay County Jail. In 20-872, he would admit his violation in the grand theft VOP. And in 21-1356, he would admit his violation of VOP for felony battery priors. He'd be adjudicated guilty, be given credit for 147 days in the Bay County Jail in case 21-4426. He'd be assessed court costs and fines. He'd owe restitution in the amount of $450 to the Panama City Police Department. Be given credit for
Panama
147 days,
City.
jail
Playboy.
time. He'd owe 50 hours community service. There'd be a $20 monthly cost of supervision. He'd undergo a drug and alcohol evaluation counseling is
does have
recommended. The
beautiful
DMV may
heart.
apply additional penalties. Be time served on the misdemeanor. Be DNA sample. He'd provide DNA sample if requested. He would forfeit any seized items.
Hello,
in the
man.
case- in the two
Davis.
VOP cases.
Sergeant.
21-1356 and 28-72. His probation would be reinstated and extended to 36 months.
This dude's
From
rapid
today's
firing
date,
us.
you must complete Keaton and aftercare, bars to bed, as an included condition of his probation. He would also have to attend 2 AA meetings per week. He cannot take any drugs or alcohol if not
Surely.
lawfully prescribed. Must
He can't
complete
wear
a
shoes
DCF
without
approved,
socks.
parenting
Ed.
class. You can have supervised contact with KG, date of birth 7/2/2018. You must complete all original conditions. Not here modified.
That's the agreement with the state?
It is, and we're also resolving a couple of misdemeanors.
Live on YouTube, Doug?
And there's a motion to consolidate those two into one case that we're also.
Because that'd be awesome.
It's the 31st.
God bless. Hi, Pamela.
Consolidate your,
Send us the link. We'll tell them where you're
sign right there. So this takes care of all
arbitrator.
open cases.
And we originally did this as a, reinstate to probation and community control, but he's
You
doing
look
Keaton,
tired,
and so
Jeff.
that drug evaluation may be done through his Keaton program.
Did you talk to her for 3 hours?
And Your Honor, do the AA classes count towards community service hours? Okay.
He'll get 2 hours of community service work for every AA and then that class.
Nothing yet, Danny B. Nothing yet.
We got our antennas up though, ready to go to it.
We don't have to hope we get a couple
All right,
of
Mr.
days,
Gibbons, state your
believe it or
name,
not.
please.
Zachary Gibbons.
Pretty crazy.
Gibbons, you just heard the announcement of Mr. Gunner. Is that correct?
Yes, sir.
Is that your understanding of the agreement with the state?
Yes.
Has anybody promised you anything other than what your attorneys just announced in open court?
No.
Are you under the
I-
influence of any drugs? or
I
alcohol
noticed
today
that
that would affect
yesterday,
your ability
Lisa.
To
That
enter
was
the
a
agreement and
bummer.
understanding the terms and conditions
It
of
would
it.
have been great to
sir.
go back.
I've been
to.
handed a plea waiver and consent form.
Judge
There's
is
the front
chewing
page.
gum, by the
The
way.
second page is a signature over the.
Yeah,
defendant.
somebody
Is that
said that in
yours?
the,
Yes.
yeah, like you
Have
don't
you had a
give
chance
them
to read
enough.
that agreement?
It'd be a
I
tough
have.
dude.
Have you had a chance to go over your VOP and your new?
Hell
charge
yeah.
With Mr. Gunner?
Yes,
Have you had sufficient time to speak with Mr. Gunner about all your cases?
yes.
Are you satisfied with your lawyer's advice and counsel?
I am.
Nina,
You understand that by entering this plea, you're waiving your right to go to trial.
I am.
You know, I hope we
You're
see
waiving your right to
Niner
require the
today.
state prove the allegations against you.
Yes.
You're waiving your right to have your attorney cross-examine the state's witnesses and contest their evidence.
Yes, sir.
You're waiving your right to present any defenses you may have to the allegations.
Yes.
You're waiving your right to subpoena your own witnesses to come to court and testify on your behalf.
Yes.
You're waiving your right to testify to remain silent at the trial and at the evidentiary hearing, and that would be your decision to make.
Yes.
Not
You're waiving
today.
your right to
I
appeal
don't
anything
think
for an
Usually
illegal
on time.
sentence.
I
Yes.
don't think
Are
he
you doing this of your own free will?
has an
I
accent.
am.
The judge?
Mr.
Really?
Gibbons, do you feel the pleas in your best interest?
I do.
Mr. Davis, do you have any your best
You
interest?
understand if you're not a citizen of the United States, you may be subjecting yourself to
You
deportation. proceedings by
understand
entering the
that,
plea?
right?
Yes, sir.
All right.
All right there,
And I
buddy.
will find there's a basis for the admission of the violation of probations by the plea to the new charge of
Foot,
misdemeanor. and
fish,
you're,
tank.
Stipulating that prima facie case. Is that
Nate the
correct?
Great.
Yes, Your Honor.
All right. Well, that'll be time served on 26, 21, 440, 44, 26.
Nope,
causing a
no
minor to become
accent at
dependent.
all on this guy.
First degree
Glad y'all
misdemeanor.
figured that out.
Assessed 147 days to Bay County Jail, give him credit for 147 days. His probation, I'm going to accept his admission. His probation is modified as follows. All
Oh, I
conditions
see the
of proof
plastic
imposed and not
chairs
paid
that
will be reduced
Forrest was
to
talking
acceptable
about
judgment.
right there over.
We stacking them, bud.
I just see him now.
$250 imposed today for the cost of prosecution of the violation of probation. Now, all these other conditions on here are not. I'm
I
not
understand the court
supporting
came over here,
these.
but why have you got this elementary school
He's only
closet?
He's pleading to a misdemeanor. Is that correct?
The VOPs, two VOPs.
It's two VOPs, but the VOP, all the other stuff, DNA sample and all that, that's not part of the plea.
Yeah.
It was done on a plea waiver consent form. It should have been done on a VOP form, but that's okay. But it's not in doing, all I'm gonna do on the VOPs is that his probation, he's reinstated probation. It's extended 36 months from the day's date.
Congratulations,
He's
your
to
probation has been
complete the Keaton
reinstated.
House and the aftercare program. This is a bars to bed, which means you'll remain in the Bay County Jail along.
Guy
until
moves
the
pretty
becomes
quick, though,
available at
even
the
though it's
Keaton
Yeah,
House.
he is pounding.
You're on probation. If there's a violation of the jailhouse rules or the Keaton House rules, they can serve as a basis for an affidavit of violation of probation. No alcohol. You're not possessed or consuming the alcohol beverages, alcoholic beverages, and not.
He's trying to hurry up
use
so he don't
any,
miss. We
illegal
got to
substance
chase
unless,
at 405.
Prescribed by a
East.
treating physician. You'll complete a DCF approved parenting class. You may have supervised contact with KG.
All right. Well, they're dealing with him. We'll come back
at
and watch for the next one to come up. We'll jump over here real quick to 430th District. Let's just see what's happening. And
His
everybody
honor, Mr. Ramen. Yeah.
And that's it. Where I am off to a
Keaton
good
House
start
rules.
today. I am 2
And for
for
every,
2, just so you know.
Mikey wins
we'll get
again.
credit
Back to
for
his pick.
And Judge, I'm fine if we want it, like I said, this originally started off a little bit differently and it was tweaked. I'm fine with him going upon release, starting the AA.
Okay.
I'm deaf
Let's do that. Let's have the AA
and have
after
everything
he's
cranked
released,
up pretty
after he's
good, but
supposed
is
to release
that
the Keaton
low
House,
for
okay?
anybody else? Because I barely can hear
She
anything.
is very low. The
All right, Mr. Gibbons, you have 30 days.
not
to
the
file your
public
notice of
defender,
appeal
but
for
the
this to appeal your judgment
prosecutor.
sentence. If you'd like to have an attorney to represent you, you can't afford one. One may be appointed to represent you at no charge. Good luck to you, sir. You step over and speak with the probation officer. All right, who we got left?
Haven't received it yet.
Let's go.
I hope she's hot.
Ms. Smith, come on up.
Come on, smoke
Get
show.
another pretrial next week. Matter as soon as possible.
$2. All right, we'll set up for May 26th at 9 o'clock.
Thank you, Your Honor.
Well, that was easy enough.
Yeah, it was. We'll come right back to it. I just wanted to show you.
Okay.
Yelled at somebody's grandma.
Just wanted to show you. See,
Oh, she's got one of those things, Creed. You attach it to your eye there, and through eye movement, you control the computer.
we'll go with that.
Or either it's a half-ass VR. I'm not sure.
We need to take depositions, so if we could have them to May or June.
We'll set it for the May 26th at 9 o'clock, and then we'll look at setting the VOP after that if there's not a resolution.
Yes, sir. Thank you.
All right, you can have a seat, Mr.
Is that a husband and wife,
Marnie Bass?
criminal
Bass
and
Corner.
attorney?
Great if it was. Dolphins fan, it's fine. Today.
Time. Stumble on in.
In Mr. Bass's case, we took depositions, but some of the witnesses couldn't be served, so we need some more time to do that. And he's also getting accepted into teen child.
If you can find something, feel free. We're doing all these continuances, it
Sal?
looks like.
Yeah.
Challenge is
See,
not an option that the state.
Danny
would-
B, YouTube likes to break a lot.
pass.
Okay.
We've extended
Yeah.
Try once, try twice,
All right, we'll
try
set May
15
26th at
times.
9 o'clock.
We got 2 hours, Danny B.
All right,
Take
you
your
can have a
time.
Mr.
I'll
Strickland.
give you a hallelujah anyways. That's for trying.
I'll give you a half a finger.
Now I thought you were gonna finger. You know, be rude.
Oh, God, Creed.
Dare you.
And Your Honor, this is Robert Strickland, and I just
Robert.
recently got his case as well. If we could just pass him to May.
May 26th at 9
Wow.
o'clock. And we'll look at setting the VOP.
A very
after that.
agreeable judge.
Yes,
Yes,
sir.
absolutely.
Thank you.
Yes. I love working in May.
Next, we got anybody else back in the box?
Anybody in the box we might
Nope.
want to let out?
Anybody back in the box? Well, we got a lot happening here, including a Zoom user up there in the corner.
You knew that Robert and Crystal Baldwin had intervened in the case, correct?
Yes, ma'am.
And you knew that their
What's going
focus in this case is on the child, correct?
If you're referring to their focus being Zeke, yes, ma'am.
Yes, that's what I mean.
I believe it's
All right,
deaf and
so,
dumb, Billy.
So their focus
Please.
has been on him, not really as much being the support system for Chelsea, correct?
I wouldn't say that.
Oh,
I would
wow.
say they
I'm a whole
have
producer here and everything.
stepped up and done what they had to do to provide a safe home environment for Zeke. while maintaining the desire for their daughter to get her life back together.
Hello, Mayor.
Well,
I
you
feel like
knew
I'm
that
really
whenever
getting to know that
when
lady.
Houston passed away, that Chelsea couldn't go back and live with Robert and Crystal Baldwin because the child was with them, correct?
Oh, are we
Crystal Ball, Creed. I'm
And
trying to
you
get
didn't
something.
do
on you
anything
guys.
to help Chelsea.
we try. I didn't realize that. Every once in a while we jump into one and it's a CPS stuff. That's not the only stuff we'll do. It's even close to that would be, of course, over at Judge Kim's, because those are capital murders, drug and gun charges. If I was in a blue card, I would smoke a cigarette. A beer. Listen, we've seen it all: vaping, cigarettes, eating 2 different steaks, and then smoking a cigarette while waiting for court. It's
Don't know what we're doing, Creed, but I hope it's not children.
Yes, I hope you're not doing
Space.
children as well.
The final frontier. These are the voyages of Helena, galactic girl from Ocean Perseon 5. And there's nobody talking yet. Well, we're bringing in the crew of the SS Enterprise here. Judge Meathead.
I like walk-in booth. Are you sure it's not just muted because everybody's talking?
Oh shit.
Or I'll just tell him if you can give him instructions to come into courtroom G2 so he can just be in person when we
Creed's
proceed.
rubbing off on me today.
И вам нужно будет в следующий раз прийти лично, когда мы будем продолжать.
What the hell is that language?
You don't understand what she's saying?
Absolutely not. No wonder she's
gibberish.
Miss Sample, are you still able
very
to hear
far
the
away.
court?
Yes, ma'am.
All right. And how are you asking to proceed on this, Miss Spencer?
For hire.
Your Honor, since she's been terminated from mental health court, I believe I'd asked to set
New
over
picture.
for mandatory docket.
They're all, the court cases here today are pre-plea. Mr. Scheitke, what is the city's position?
Thank you, Your Honor. Due to the number of cases, the warrant history, the FTA, the termination from mental health court, the city thinks it would be appropriate for Ms. Sample to turn herself in on the warrants. I believe they're book and hold, and then be set to a future court date.
Yes. At this time, the court, based on the multiple fails to comply with essentially anything being ordered by the court to turn herself into jail, the court's not quashing warrants or setting court dates forward. Ms. Sample,
Uh-oh.
you have to turn yourself into jail.
Yeah, we've
or
seen
you'll
her
be picked
before
up
with
by
the
law
space, haven't we?
enforcement before you can proceed
I
in
already
your
did jail
cases.
time though.
Uh-oh.
The 3 days, I already did that. Why do I have to do it again?
Talk to your attorney, but at this time, I'm not setting court dates forward until she turns herself in. The warrants will remain out as book and hold warrants.
Mm.
Mm-mm.
Am I
So
done?
turn yourself into jail or we can't hear your cases.
All right. Thank you.
Thank you.
No, Your Honor.
Our guy.
Hello.
Need a
Vladimir
thank you to the
Baginski
Lord's
just
work.
showed up.
Kind of surprised that this judge didn't go off on
I was
somebody that's
expecting-
you know what I mean?
I've already done that. Vladimir Brabonsky, well-known, well-renowned vodka smuggler.
He has left the armed forces. He was
Whoa.
Nice beard, Chewbacca.
but he's still in the town that he was in. He's unfortunately
Whoa.
Just facing some financial hardships. Relocation is not an option for the treatment. That was the first option we were looking
Thank you,
at,
Shirley.
was if he could just move
Tanner
back
in
to
the club.
Washington or move to a bigger city that has the treatment options. Before he moved, Mr. Gilly set up treatment in Tennessee. However, the orders changed to which base he was going to. He's in a very small town as opposed to a very large one.
Good so far,
he's
Vic.
talked
No
to every
complaints.
treatment agency in his area. The nearest place that can meet the requirements of Washington State due to the length of the program and only due to the length of the program, is a 5-hour drive. Unfortunately, that's not viable for Mr. Gilly.
We saw a girl the other day who was
We've
walking
discussed
3
options.
hours to school.
We were hoping that the court
It happens.
telehealth
Eric Redbeard for sure.
either not a location in Tennessee or more likely a location in Washington State.
While
may
being
be able to
homeless.
meet these requirements through telehealth options, but just showing up in person is
Nathan.
not seem viable from a logistical standpoint at this time. Asking Mr. Gillett to do so is a bit beyond his means. His options are to abandon the home that he and his partner bought.
Real quick, Creed, I want to show you this.
Or, because
It's
they
like a
won't-
confession booth. We're putting these guys in these little glass booths.
Time and date set for a probable cause conference.
Okay, I like that. We can watch this.
Please.
I'm cool with that.
Ben Gonick for Mr. Willis.
And,
Just talking about
Your
Willis.
full name, please.
Apparently, I missed our guy's announcement.
Prosecutor's office. Mr. Willis, have you had enough time to talk to your attorney before
Congrats.
today's court event?
No, sir. No, Your Honor.
Sorry.
Donna, you need to talk to Mr. Willis at all or not?
I do, Your Honor. If I could have a breakout room with him for a second. I had for some reason, the Polycom didn't work this morning.
Hey, Chris.
Good, we'll do
The
this.
what?
It happens. I understand.
Mr. Gonick, as well as Mr. Willis, into a breakout room.
Thank you.
Right. Sorry, JJ. I forgot.
We're heading to a breakout room, Creed.
Yeah, we are. Well, we got a little in the action. We'll go back to Beard Boy.
Now, if he's on probation rather than deferred prosecution, there's a lot more flexibility. He doesn't have to do a certified program that meets deferred prosecution.
Joe, thank you. You guys
Any
coming
program
through
that satisfies
today.
whatever
Appreciate it.
requirements the court sets. But of course, he wouldn't get the benefit of the deferred prosecution. He'd wind up with that license suspension. He'd wind up with
Oh, what's
mandatory
the
minimum
mandatory
penalties for the DUI and all the other consequences that the deferred prosecution has the benefit of helping him to avoid. So really, it's a binary choice. He's got to find the right program that meets those requirements, or he's going to wind up with his deferred prosecution revoked.
Yes, Your Honor. And so we're hoping that an option becomes available. He is looking into other alternatives.
But that man can start a chainsaw in 2
This time we'd
seconds.
simply request this be set over. We're hoping we can come up with an alternative to a 5-hour round trip this time.
Any way possible that he doesn't cut
Really,
down
I
trees
will
for a
give
living.
you some more time to do that because I
I don't know.
it's
I
not
saw
in
somebody
the
say he looked
crowd.
Metro, so maybe not.
Their prosecution programs
Wow.
have more challenges, and it sounds
Whoa,
like
Amy.
you're kind of in the back of beyond out there somewhere in Tennessee, so it's going to be even harder.
The
But
back of
you're operating in good
beyond.
faith here. I don't believe that you're trying to just evade your requirements. It sounds like you're trying to do the right thing here. So I'll give you some more time to do that, and we'll check your progress here.
Hello, Ann.
But keep in mind what I said. I can't allow you to stay on a deferred prosecution if you're not actually
I
in a
can see that.
qualifying
Back of
program.
beyond.
So let's put this over for about.
I say
90
he's a
days.
cable guy.
Yeah.
Cable
Are you
guy.
also- Mr. Gilly, are you also reporting to a
Best
probation
restaurant in
officer?
town. Go.
Yes, I am.
Okay, and that is that.
Which one is it?
Ms. Dickinson.
Medieval times. Come on.
Carissa, yes.
Yeah, stay in touch with her too. I'm not sure how much help she can be from this distance, but if she can be, she will. She's pretty creative and resourceful too. All right, we'll get a date mailed out to you for another hearing in about 90 days. In the meantime, can
90
I just
days,
verify
Jerry.
Your address is on Horse Creek Park Drive in Chuckey, Tennessee.
What a great address.
All right, we'll get that hearing set and mailed out to you.
There you go. Glenn.
Thank you, Your Honor.
All right, good luck, Mr. Gilly.
Thank you.
Thank you, Mr. Gillett. Thank you, Your Honor.
Good luck out there in backyard of
Back to you, Mr.
beyond.
McDonald.
If we can next call Mr. McLean.
All right, good morning, Mr. McLean.
And Your Honor,
All right.
Good morning, sir. Sorry.
And Your Honor, when Mr. McLean was last before the court, he was actually here with me. He was in the process of transferring from Northwest Resources to Stop for treatment. At that time, he had an intake scheduled just after that court date. The process is a slow process, unfortunately. He went through the eval, he's gotten that done. We don't have proof of treatment yet, as Mr. McLean has his first treatment meeting this evening. At this time, we'd simply request that the sanctions hearing be set over to show proof of that treatment. He's not trying to lollygag or drag his feet or anything, Your Honor. It's just the reality of transferring and the slowness of getting in, or the slow
Look at
process.
that beard shot right there.
Yeah, that is a nice shot.
He should be at this time.
If you're in the beards, that's the
Yeah, I
money
was
shot.
looking for treatment status report, and I didn't see anything in here.
That
So
looks
I-
like we're looking at the back of his head.
Hello,
All
Hugh.
right, any objection to that from the state, or I'm sorry, from the city of Tumwater?
No, Your Honor, thank you.
That look good as a redhead, you're saying, Ann.
All right, Mr. McLean, 3rd Avenue in Lacey.
Yes, sir.
Chris, I'm sorry. I hope it goes
All right,
as good as
sounds like
one
you're
can
doing
go.
everything
Hope you see
you
lots
need
of
to do to
family and
transfer your
stuff.
treatment from one agency to the other, and I'm accepting that explanation that Mr. McDonald offered for you.
Very.
We'll continue this sanction hearing out.
That happens.
60 days or so would be appropriate. So we'll see you in a couple of months, and hopefully you're going to have some progress reports already filed by that time, and everything will be fine.
Thank you, sir.
All right. Good luck, Mr. McLean.
Thank you. Have a good day.
You too.
Oh, here we go. The Ginger Warrior.
Okay.
Yeah.
Mr. McDonald.
Your Honor, I've not had a chance to speak to Mr. Carl yet. He joined after we'd resumed.
Carl, Mr. Carl.
If I could request a breakout room, I'd greatly appreciate it.
Oh, come on,
The
him.
person who just came in the courtroom, I'll find out who that is.
Oh, we got a surprise person
Okay.
showing up.
And yes, Mr. Campos is here as well.
Oh, Mr. Campos, is this a fake trial?
May I have a phone number for Mr. Campos? I'll give him a call as well.
Yeah, Mr. Campos, would you come up to
Look
that?
at that beard, like from this angle, looks like it's like 10 times the size of his face.
I think he has a small face.
Yeah, right there. He can hear you. 360.
Oh, we got somebody in the courtroom.
Oh, look at that.
15.
Excellent. Mr. Campos, if you would go into the hallway, I'll give you a call. If you don't have a call from me in about a minute, the reception in there can sometimes be bad. If that's the case,
Just
please
wait
go
2
outside
more
and make
minutes.
sure to return once you and I, or to the courtroom once you and I are done talking.
And then I'll come out and I'll say your name 3 times.
Okay.
in the hallway.
So we'll give you that breakout room too with Mr. Carl. And then
Carl.
I see Mr.
Randy
Laconin
Carl.
has logged in. I know you've got a hearing with Mr. Hart. Are you ready for that?
Your Honor, actually, I am not entirely certain that, although I haven't withdrawn, I'm not entirely certain Mr. Hart is still my client. My contractual duties are over, and I see that he requested a public defender, but because he was inpatient, I haven't had an opportunity to actually talk to him and verify that.
Okay, there's
So-
his work truck.
I am just logged on a little
Okay,
early,
that's a Red Bull.
hoping that when he shows up, I can have a quick chat. with
Okay,
him.
so whatever that logo is on his hat is the
no,
same that's on the side
I
of that
didn't know
truck.
if you had him
Hey,
in your office or
you're
what the
right.
situation was. So I thought I'd just give you the opportunity before I took a recess.
I appreciate that, Your Honor, but unfortunately, I guess you get to take a break.
Okay.
Oh, of course. Well, now I get to jump somewhere.
Wow, look at them. Very quick. Oh, that was a nice one that you had pulled
Oh yeah,
up. Thank
the
you.
judge stepped up just like 30 seconds ago. He
That's,
got up and said he was done talking to us for a second.
That sounds about right.
It's been one of those days as far as like getting something to hold on to.
Yeah, one of those days, I guess.
And so,
Thank you, Your Honor.
I
I'll-
guess
down
let me
here
check
real
with the
quick.
other counsel.
Oh, there we go.
Mr. Arts, theoretically, would you be available tomorrow for the shelter care hearing?
Judge that's talking, he's a bit mistaken of what's going on.
The time, I do have another shelter care hearing scheduled for tomorrow in Mason County, but depending on the time, I could.
All right, and Ms. Butler.
Sounds
Your Honor,
about
my
right.
request is actually to proceed today in regards to my client. He is in custody and is agreeing to dependency based upon his unavailability. I am in meetings tomorrow, and so I'm concerned about being available. If we could proceed in regards to my client.
You okay,
I was also
Leland?
concerned. I'm looking at the schedule and I got a administration. I don't think tomorrow is going to be feasible based on the court schedule. So I think it makes some sense since both of the Rednauers are apparent, not both the Rednauers, Mr. Howe and Mr. Rednauer are agreeing.
I saw that real quick,
I think
JG.
we can proceed in that fashion now with the agreement. And then as to Ms. Rednauer, we can continue her portion, but potentially.
That's
of the
definitely-
shelter care hearing to a different date. Not tomorrow, it's most likely going to have to be
So
next
our
week.
luck today is it's either CPS, they're done immediately, or we jump in and they're just talking about when we're going to have the next case. That seems to be what is happening today.
You got this though.
On your client.
No, Your Honor.
Hello,
You'll
Judge
wait
Jen.
formal readings.
What's wrong with Jen
I'm
today?
sure he's probably familiar anyway, but you do have 4 warrants, Mr.
Hyman.
Cruz, and they start with warrant 22W 004764. The first warrant charges you with kidnapping the victim in this case. I believe there's like 4 of you that are co-defendants and you all got charged with the same offenses, and some additional offenses were added. So the first
Wow.
one charges you with kidnapping, armed robbery, possession of the firearm during the commission of a felony, and you're also charged with violation of the Street Gang Terrorism and Prevention Act. And pretty much what that's saying is that the
You're a piece of
kidnapping
shit.
and robbery were done in furtherance of some type of criminal street gang activity. And for that reason, you're not into, well, the armed robbery, the kidnapping, and the gang act do not permit me to set bond for you. So you're Superior Court
Send it,
only.
Vicky. Yeah, I wanna see
And you may already know that, but anyway, your attorney will follow up with you,
0.0.
Hyman or whomever has filed the entry to let you know when you'll have your preliminary hearing, and that will be addressed on a future date. All right, Mr. Cruz, is there anything
You
further?
gonna talk
Ms.
about what a
Hernandez,
pillar
Mr.
of
Cruz?
in the community he
Yeah.
is? Or?
Okay, all right. Mr.
Cruise your
Cruz,
ass
you're
on back to that
Thank
cell
you.
because you're going nowhere.
All right, now we do have a co-defendant with Mr. Cruz. I know that they added this charge.
Jen Hyman just busted right out of there real quick. Did you see that?
Yeah, busted Hyman.
And that's going to be Mr. Ramirez, and I believe, yeah, Mr. Coleman.
Yesterday, so she
Good
had a
afternoon,
little
Ron.
technical
Good afternoon,
difficulties.
Mr.
for those of you
Ramirez,
who weren't
come on
with
up for
us,
me, please.
yesterday.
And he was already in
Thursday,
custody,
flipped.
right?
Yes, Your Honor.
The green
Okay,
screen was
all
flipped
right.
on.
So you have one
Yeah.
additional charge, and that charge is the gang act as well, I believe. Let me pull it up. That once they determine that these alleged acts were in furtherance of gang activity, that's the additional charge, of course, which is Superior Court only as well. So let me just formally read it into the record. Give me one moment. My computer is doing something. All right, and young man, you're charged with one additional count. I know you have other charges already pending, but this is violation of the Street Gang Terrorism and Prevention Act, and that's
So they're all
22W0,
figuring out that
warrant
these 4 defendants are all
22W004.
gang related.
768, and the warrants allege that these incidents happened on January 27th, 2022.
That's
Have you guys
interesting
had
that
well,
that
have
is a
you had this
0
first
bond
preliminary hearing?
automatic.
I know we did a prelim on some defendant. I'm not sure which one it was.
Yes, we had a bond hearing on Mr. Ramirez, Your Honor.
Okay, all right, sounds good.
I don't know if we
All
have a
right.
prelim yet.
Okay, well, you have this additional charge. So I don't know if you want to have to go back to the court or how that works, but we'll notify you of the preliminary hearing if he's still in custody, okay?
Okay, appreciate Your Honor.
You're welcome. Thank you. Okay, thank you, Mr. Coleman. You're excused from court. And
Okay.
Mr. Ramirez, you can return to custody.
Take care. And thank you to Mr. Niner again also.
Ooh. Shout out to
Now,
Niner.
I
Shout out
have,
to Niner. Where's Sap? She
those
take
are
the
the
day
Superior
off
Court
today?
only, and
She's
I
at
am,
home crying. She called in sick.
let's see,
Vicky,
so
where'd you
Mr.
send it? I can pull
Coleman's
it up.
going to be off the screen in a
Did you
moment. Okay.
email it?
I think that I have taken care of all the Superior Court only cases. Let me see, make sure I've handled those. And I have, all right.
Yeah, she just
I
sent it.
think we're just going to go in order. I know
I'll
there's a
pull it up,
victim on
find it.
position 2.
Judge Jason.
I believe
for
we've
me.
handled all the private attorneys as well.
Niner in the house,
Let's go
everybody.
ahead and
Good to see
just
him.
start in order with position number 1.
Does he have a
Michael
yarmulke
Banjo,
on or
you
whatever
can
that
come on
thing's
up to
called?
the podium, please.
That's how my hair was when I was in
Your Honor.
6th grade.
Good afternoon. And guys, there's going to be an additional charge for Mr. Banjo. It's just a misdemeanor obstruction. I just put it on this one because it,
Out the
Did she say
banjo.
I
banjo?
actually issued that warrant, but that's, we're gonna handle that
Banjo.
misdemeanor warrant today too. Okay, now,
Banjo.
let's see, in this case, Mr. Banjo, I know that you were previously arrested for multiple types, similar types of offenses, but they rearrested you. I guess they went to arrest you on prior offenses is what they said, which is this one, that there were outstanding warrants. This warrant is 22W004709. The warrant charges you with 8 counts of possession or display of false identification. It looks as though you had, I just want to make sure that I'm understanding, 8 different fraudulent driver's licenses from different states in your possession.
They were all expired.
And I believe he had prior history regarding fraud, and we'll get into that in a moment. There's also a misdemeanor obstruction charge. He tried to flee when the officers. So they went to go arrest him for this warrant. And when they went to arrest him on this outstanding warrant, he allegedly fled. And so he has a misdemeanor obstruction. So
We got to
now the criminal history, just want to make sure I have it because I did it kind of quickly.
Sorry.
in my
Vicky,
prelims,
real
but
quick,
I showed
Vicky,
that he
this is
has,
actually
some
live.
Maryland history, same type
So-
of theft,
You can't rewind it.
scheming,
no, I can
identity
rewind it.
theft, having false government IDs, and those are from 2021 in Maryland.
I can't do the math.
I also show that there are 3 pending cases: January 2022, possession of marijuana, driving without a license, fleeing, and
no.
another count of possession of marijuana. I believe there are 2 different charges involving somewhat of the same offenses. It's just one includes and no license, fleeing. Then in March of 23rd, identity fraud, conspiracy to commit some type of financial fraud, and identity fraud. And so I believe those are the charges. Again, all same type of alleged activity. And Ms. Fortson, do you have any other criminal history you'd like to supplement?
No additional
Disregard what I
history,
just said,
Judge. In this case, the state is
No.
recommending a $7,000 bond.
Okay, Mr. Niner, favorable information, please.
Here it comes. Get
Thank you,
ready.
Your Honor. Mr. Banjo has made Georgia his home. He's lived here for the last 5 months.
Your Honor.
He lives here with his brother,
I'll
his
BRB.
sister, as well as his
Yep.
brother-in-law. And he has gotten a job at a pizza restaurant. He's a pizza cook. He got that a couple months after moving here. And he does also have some college education, 3 years
Pizza clerk.
at Prince George's Community College for Business. Your Honor, this
Monkey
is not
business.
a violent offense. He doesn't have anything of violence on his record. So we would be asking for you to take that into consideration and give him a $4,000 bond. I think that's reasonable, given the charges and his ties to the community. $4,000 bond.
Okay. There's some information provided to the court that makes me concerned, especially with the Maryland information. On this one, it is going to be a $7,500 regular bond. I don't know what the bond was on the previous charges, but this is 8 counts. And evidently there was a statement, just want to share with you, that was provided indicating that he was using those to open accounts in different victims' names. So that definitely is a concern of the court. And
It's
then
a bigger
on
case
the,
than just that.
misdemeanor, let me just go back. Hold on 1 second. Let me sign that bond.
Can we please get the likes? I appreciate that. We need 100. So. Or
And then
YouTube
he's
will
only
shut
been in
down our
Georgia for
channel.
5 months, and he already has fleeing, identity fraud, conspiracy to commit financial fraud, identity fraud, same kind of scheme and thefts from Maryland that just happened. So he just got arrested for about 6 or 7 charges of the same thing. So I'm definitely concerned that while he's in our state, he's at risk to reoffend and continue the same type of conduct.
guy's-
And then let's go to his
Am I the only
misdemeanor
one
obstruction,
that
because he already
feels
has
like,
a fleeing.
yeah, he
in-
definitely
in,
doesn't need to get out.
January of 2022, and now he's being charged with an obstruction. So let me go.
I mean, if he has all these fake IDs and things.
Sir, stop talking. Stop talking.
Shut up,
Please
Banjo.
Please stop talking, okay? My
Banjo.
understanding is they went to arrest you and you fled. I'll read the warrant in open court. Give me a moment, please. I thought, oh, that.
Hey, gotta do what you gotta do.
Maybe
Please,
that's
yes. Likes.
Hey, hold on.
Okay, so I'm with the judge. You know, $4,000 to me doesn't seem like much. This guy has the means to apparently come up with all these fake IDs. He's
Um,
opening accounts in people's
Ms.
name.
Thomas,
He could
what's
definitely go on the
case number
run.
for that misdemeanor?
He's already fled.
Because it's not coming up under the regular number without the A.
Put a B behind it.
A B?
Put you back into
It's
it,
showing
Judge.
that same case number with a B is for another defendant taken out by a villa. Let me see if there's two co-defendants on that one.
Where in Georgia? That I don't know. Let me see if I can
Unless
look
he
real
has
quick.
two names. Oh, no, that's Michael Banjo. That's really weird because if you look
Doesn't
at the
say.
listing, it uses another name. Anyway, yes, this one charges you under warrant 22W004777. Says you did, this one's a misdemeanor obstruction, willfully obstruct officer of villa by attempting to run and resisting arrest and a pending case related with B. Okay, all right.
It's
So
like
that's a
the
misdemeanor
deeper we
charge.
look, the more we find on Mr.
That'll be a
Banjo.
$500 bond for a total bond for $8,000.
I heard that. What'd you do?
for all
Find
the
another name or
charges
something?
that are pending.
Mm-hmm. She come in with 8,000 strong on them.
All right, you're excused from court.
Our Niner over here was asking for the sweet $4,000. She doubled down and went for 8.
Well, he tried.
Ms. Fortson,
Morning, Judge.
good morning. Are
Um,
you calling
afternoon.
bank? Are you got me saying morning. Is the state calling the victim in this case?
Judge, we
Oh.
were, she
That's right. I'm sorry.
She no longer wants to address the court.
Okay, sounds good. All right, so.
The love of money, Your
Felicia
Honor.
Banks, you can come up to the podium for me, please.
Oops, sorry, I got it. Vicky, thank you. Yeah, I'll take a look at later. It's just too hard to do on the fly right now. Because it's like a 4.
Okay, Ms. Banks, you're before the court under warrant 22W003710. These warrants are outstanding from February 15, 2022. And the warrant charges you with
Outstanding.
aggravated assault with a weapon against the victim in this case. Give me one moment.
That's a good job.
Okay.
Damn it, Fletcher.
And so I show the following criminal history, 10 cycles, a 2017 and 19 failure to appear, 2020 violation of probation, and a 2019 giving false name and theft by shoplifting. We have a victim in this case. All right,
Many
the state's
thanks.
recommendation on bond or any additional criminal history?
No additional criminal history, Judge. We did have victim contact. The victim wants you to know that there is a history of unreported violence. She wants you to know that she's very concerned for her safety and fear of retaliation. She was treated at the hospital, and it is her request that bond be denied. The state is, she also is asking for a stay away. Judge, the state is recommending a $25,000 bond and a stay away from the victim.
25.
Do
25K.
you does the state know the extent of the injuries to the victim? It was kind of a strange instrument used.
One hell of a black eye, Your Honor.
Judge, all I know is that she was treated at the hospital. There were lacerations and bruises. I do not know if stitches or surgery was involved. I do not have those notes from my victim advocate. If you'd like some clarification, I'm happy to get the victim advocate on the phone. I do know that we did talk to the victim.
Okay, no, that's fine. And I presume that they're no longer living in the same residence. This happened in February and we're just now taking you into custody. But I'll let Mr. Niner handle that. Mr. Niner, go ahead, please.
Let's hear it,
Thank
Minor.
you, Judge.
Favorite part.
Just one moment, please.
Take your time.
It seems like she used some sort of weapon
Yes,
to
Judge.
beat
So
her.
as far as the relationship between the alleged victim and Miss Banks, she did not purport to me to really know this person that well at all. So a stay away order, I think, should be fine. I have no objection to that. I understand the alleged victim's desires for that. So I think a stay away order is fine. But for Your Honor's information, Miss Banks does deny really knowing this person well, and they don't live together or anything like that. So a stay away order should take care of any concerns for victim
yeah.
contact.
Should you know your
This is
attacker better?
Ms. Banks' home. She's been in Georgia for the state of Georgia is her home. She's been in Georgia for the last 17 years. She's 31 years old, so that's almost all of her life. As she has two young
Look, Mayor.
boys, a 9-year-old and a 4-year-old. And Your Honor, I will let you know she does have some mental health issues. When I was asking her about her employment, she's in the
Virginia, that's great.
process of trying to get SSI. It's been a difficult
Good stuff.
process for her, so I would like for her to be out of custody to further that process along. It's certainly not going to be any easier in custody. It's already been quite difficult. And she has a patient at the DeKalb County Community Service Board at Winway, the mental health services off of North Decatur Road. So Your Honor, I would suggest that you give her a low bond with the conditions of stay away from the alleged victim, stay away from the incident location, a mental health evaluation, report to Winway. She is already a patient there. Any conditions Your Honor deems fit. And
He just told me all the reasons
she
she should stay in, to be honest with you. I'm not
No
going to
kidding.
lie.
Something more in the range
very
of $1,000 to $3,000
He's
is
trying.
more reasonable for her.
Our boys.
One
And her history, she doesn't have a history of violence. That's
$1,000
been
to
provided me.
$3,000 bond. 25 on the
Well,
other
that's
end.
true. She has false name, theft by shoplifting, 10 cycles. I'm going to grant a $10,000 regular bond. Special conditions will be to comply
Middle
with
of
the
the road.
mental health treatment and that of which she's already participating, and to have absolutely no contact with the victim, Ms. Moore, in this case.
Okay. That's where we're at. Thank you, Jim.
Well, Drew helped a
Continue to
little
comply
bit.
with the mental health treatment program that she's already.
He asked for 1,000 and it was 10, Creed. So yes, he did it.
She asked
One
for
hell of a
25
job.
and got
Let me
10.
know.
Condition save.
Okay, everything's good to go. Okay. All right, ma'am, your excuse from court, your family have to pay a little over $1,000 to bond you out.
Why are you putting it out on her family for?
Yeah, what? She ain't stole enough. Pay for her own damn bond.
Okay, Devin
Stephanie, you think
Bowers.
he's a good attorney? He's all right. I've seen worse. Meg.
Meg.
Meg is the worst.
He do you think that he has to find all the good stuff
All
that he
right, so
says?
you have 3
That's
warrants
on
that
him.
begin with 22 W004745. First
Next.
warrant charges you with possession with the intent to distribute marijuana. You're
Oh,
also
no.
charged with possession of a firearm during the commission of a violation of the Georgia Controlled Substances Act. You're also charged with obstruction of law enforcement officers. You fled the scene while they were conducting a search.
Got a new candidate over here, a new customer over with Clark W. Griswold. Let's check this out.
Standby defense counsel. The charge against you alleges that on February 16th of 2021, that is last year, you delivered the controlled substance alprazolam, aka Xanax, and if convicted, you face up to 4 years imprisonment. You understand the charge and the maximum possible penalty.
Yes, Your Honor.
How many she have?
Agree to an attorney. If you could not afford one, the court would appoint one for you. In addition to that, you have the right to a jury trial on this matter. If you wanted a trial but not a jury trial, you could request a bench trial. At that trial, the prosecutor would be required to prove your guilt beyond a reasonable doubt. If the prosecutor could not do that, the matter would be dismissed. At that trial, you'd have the right
To
to remain
imagine.
silent. If you chose to remain silent, your silence could not be used against you. On the other hand, if you wanted to testify, you could. You'd have the right to have the court subpoena or order witnesses on your own behalf to be present, and you'd have the right to have you or your attorney ask questions of witnesses against you. Do you understand your rights?
Yes, Your Honor.
You plan to hire an attorney, or would you be seeking a court-appointed attorney?
I'm all right with Kilo.
What?
We'll take that. I mean, it won't be Mr. Gilo, though.
Okay.
I believe.
That's all right.
But you're seeking a court-appointed attorney.
I just want
Yes, Your
an
Honor.
attorney with gray hair and glasses, Your Honor. Do you have any of those?
At this point,
Yes, I work at Boyd Mountain.
Give me Gilo.
about how much do you bring home every week or every 2 weeks?
I get paid every week and I bring home $200 to $300 a week.
If I'm selling Xanax, it's a little bit more
Working
though.
normal hours, I can bring home anywhere from 8 to 1,000 a week.
All right, well, depending upon where we are, but at this point, especially given that it's a felony, I think you are eligible for a court-appointed attorney. We're not saying it won't be Mr. Gilo, but this court only determines.
Well, highly.
Eligible
Long time no see.
determination as to whether or not, as to whom it will be. Mr. Fenton, as to bond.
Yeah, a couple of things I want to say. We don't have an objection to a PR bond, assuming she's still local. I saw a Camp 10 address before, assuming she's still local, no objection to a PR bond. More importantly, I need to disclose that the lab test in this case came back negative. So we were going to amend the charges to delivery of an imitation controlled substance. However, in light of some other factors that I'm not going to put on the record at this point, we are willing to dismiss
We're
this
here.
case as long as she pays
Hello?
$100 restitution, which would go back to the agency. So if she can bring a check between now and prelim to our office made out to the relevant
Cash.
agency in this case, which I think she's aware of, we could forward that on and we will process.
Who you
it
calling
out.
crazy, SA? Don't you know she's local?
So, ma'am, I know there's something you wanted to say.
Hey, Delcy.
Say this is probably not the time to do it.
Welcome.
My suggestion to you is that you think
I have
about.
a question.
Well, I will answer it if I can. Go ahead and ask it.
It was to do with what he had just said to me. He said, I can pay that money within now and when. What is that when time?
Basically, how long, if you decided you wanted to do it, and I'm not saying you should or shouldn't, but it's your determination. If you decide you want to do it, how long would it take you to do it?
My God, mister.
I could do it tomorrow.
That's terrible.
Okay.
Tomorrow's fine.
All right, what I'm going to do is set this for a hearing in 2 weeks. An
Okay.
advantage, if you wanted to take advantage of that, if you did that, the prosecutor is saying that he will dismiss the case, which would also
I'm
mean.
agreeing with that
Okay,
first
hold
option.
on, just one, because
I'll take that deal, Your Honor.
I will hold off on appointing an attorney for you at this point. If for whatever reason you change your mind or the prosecutor changes his mind, I would reappoint an attorney for you, but that will save you $350 if you don't actually have a court-appointed attorney.
No,
Is that
All
agreeable
right,
with you?
Haley, by the way, no, I'm
Thank
not.
you very much.
All right, and Mr. Fenton, once again, she should have a $100 check dropped off at your office, made payable to the agency that arrested her.
To the agency that investigated the case, which I'm sure she's aware of.
You know.
And if she's not, she can contact me at any time.
Yes, Your
To
Honor.
the
You know,
secret.
you know where the prosecutor's office is?
Isn't it in the courthouse somewhere?
Yeah, do you know where the elevators are, kind of in
Good
the back
call.
of the building?
In the district court, right? Or in the
Yep.
circuit court?
I've been there like 50 times. I don't
Or
remember.
the one down by the high school.
Okay.
Which is district court.
If you come.
$100.
You want her to drop it off at your office?
Cash.
Yes,
I think
please.
that- yeah. So ma'am, if you come to the elevators and go up to the 3rd floor, you'll see the prosecutor's office as soon as the elevator door opens.
Make sure you go and pick up an iTunes card to pay for it.
And so.
Thank you, Your
we'll
Honor.
Yes.
set this
Or Google Play.
We'll set this for a hearing in 2 weeks. Actually, we thank the prosecutor because I'm just processing it, but we'll set this for a hearing in 2
I
weeks.
might understand she was selling fake
Do that, Mr.
Xanax.
We then file in a nollie.
That's correct. File a dismissal that very day.
So that would, and you'll get a copy of that, ma'am, but if you put that in, you won't even need to appear.
I know he did say check. Can you imagine?
Be on the absolute safe side, you could.
How about a money order?
I didn't
Mr.
appear
Delo,
on
I know
today.
you're here and she did request a court-appointed attorney. Do you have any comments at this point on bond?
It'll clear.
No, Judge.
So, ma'am, it will be a $5,000 person
Or
recognizance.
constant stretching is really
You're out on bond until this matter is
refreshing.
dismissed, assuming that
And
we
her
have-
weird, like,
And you don't have to post any money. But a condition of the bond is that you do not consume or possess any drugs unless they are prescribed for you.
no problem.
And you do know I go to the methadone clinic, right? Your Honor.
Okay, well, those are, yeah, and those are
All
prescribed.
right, I just
for
wanted you to be aware, that's all. Okay.
Okay, and I do appreciate your disclosure of that.
Your Honor, you know I go to methadone clinic. I've seen you there several times in line.
Yeah, I'll be seeing him tomorrow.
Okay,
I'll be here till approximately 2 o'clock.
All right, I'll be in between 9 and 11.
Thank you.
I don't. Sure you will.
Who's giving her the $100? You think?
Sure, Jan.
Niner, 1,000-yard stare on
I
him
think
right
that
now.
they just couldn't make a determination and nobody took ownership of that.
Ask you if you
I just didn't. I don't know. I feel like we're going to see that young lady again.
I'm
Or
not
it's
quite
just
sure.
never
It looks
gets
like
out.
they charged him with possession of the gun and the drugs that were in the book bag, and I don't think they charged everybody. But
Pew, Your
anyway,
Honor. Pew.
it's just one change, Ms. Thomas. I'm so sorry to make you white it out. It's 2,000 on the. It doesn't make it. It may not make a difference, but to me, the 2,000 on the possession with the intent, since they were all charged with the same. So your total bond is $6,000 regular bond.
This
Go ahead
judge
and get
laying down
excused.
some
It's a little bit different, but
hefty
it's still a
bonds.
different-
Yeah,
different
today's kind
amount.
of big money day.
Let's see what Mr.
I'm kind
Jackson
of
has
surprised
going
that
on
that girl
here.
only had to pay $100.
Yeah,
And
did you
get
catch
the
that too,
charges.
JV? So that's I guess what they were talking about is they weren't even real
So
data,
Mr. Jackson
right?
was
Right, plug
charged
down.
with, let's see, under warrants 22W004748, possession with the intent to
BRB, I think
distribute marijuana as well. Oh, let's see, in the driver's side panel of the door. And you also allegedly had possession in your pocket. Okay, so this is a different possession, a different amount. It seems to be, and then driving without headlights. Okay. Let's see, on this one, if you guys could just give me a minute, my computer is doing something. Just give me one moment, please.
Judge, what's all these livejasmine.com things popping up on the computer here? That's my question. Oh, well, while we're waiting for the judge to pop back in real quick, please like this video. Over 120 of you here right now across all the platforms. If you're on Facebook, please share this out. Facebook needs way more court. Way more. Oh, you need to go back and watch last night's show then. If you haven't seen the OG show from last night, you need to go watch it, Haley. It's good stuff. I guess so. I would jump over to Creed's, but I can't turn his volume up. So let's stick with this and let me pull up something else over here. I'm gonna pull up what Creed's trying to watch. This guy, I don't know. This dude looks kind of dangerous. Maybe I'm just being, a jerk, which is possible. But let's jump over here and see what's going on. Judge is speaking.
He added a no contact provision at the last court hearing. I did indicate that I would review bond again. I don't have a known residency here. Does he reside in Clinton Township, Mr. Smith?
I defer to my client
If that's your real name.
here in Monroe County with somebody named Alicia Allen on Peter Street.
Alicia or Felicia? Alicia. Alicia? And how do you-
Alicia, not Felicia, Your Honor.
Did you know her before?
No, I haven't, but she offered while this is going on.
This guy looks pretty innocent. I think we should let him on out. He seems fine.
What about employment, counsel?
He's self-employed, I think.
Local 22.
Local 22. Okay.
And I have my own business too.
Yes, I know has his own business because I saw that in the voicemail. So he's a painter.
Oh, he's a
The other
painter.
two factors I
He's a
looked
real
at last
Picasso.
night, it appeared that there was a bench worn out of the 38th District Court for contempt. That may be a civil or traffic matter. Is that what you're referring to or not?
I think that might be a traffic matter.
So you think that may be, do we know or not?
We don't know. I'm just taking my
It
client's
is,
word
it's a
for it.
windshield ticket, Your Honor. It's out of East Point.
Okay. And what about the,
$110 ticket.
okay, so I'm not concerned about that. What about the warrant out of the?
Why are we doing all this off mic talking, by the way?
42 or B, District Court in, for domestic violence third? What's the status of that, counsel? Do you know?
Is that the one from New Baltimore where they have a hold on?
It's 42.
No relation, Billy? You sure? Your Honor, I'm a painter.
Yeah, I think that might be the one from New Baltimore that they have a hold on.
It's a domestic violence third, a felony, is that correct?
Domestic violence third is a felony.
And that's what that warrant is for, that correct?
I believe so.
And
What about the 16th circuit? There was a drug charge pending on the 16th circuit. What's the status of
Dolphins
that?
fan. Who's he going to fight at
There's
WrestleMania?
not
Do you
gonna
know?
Be a hold for that, as far as I know.
Do you have another court date then on that or not?
No, that was case dismissed in 2020.
In prosecution, certainly there are a number of factors that I look at, sir. The purpose of bond is not to punish you, but is to make sure that you come back to court and also to protect the community. I do see that you do have a record here. Counsel, do you want to address bond?
Your Honor, absolutely.
That was my guess too.
Extensive criminal history.
Same page.
Involving other kinds of theft as well as violent crimes, including one prison stay. According to pretrial services, there are 3 active cases, as the court indicated on the record in other jurisdictions. The defendant does not appear to have any clear, stable residence, nor does he have any significant ties to Monroe County for pretrial services. We'd request that the bond remain the same or be increased.
I know that we were last in court. The court did address bond. That was on the 24th. I have on here defense attorney to investigate outstanding warrants. Certainly, the court doesn't want to guess when it sets bond, Mr. Smith, and that's why when we were in court the last time, I would like to have more specific information on these outstanding matters. For instance, the domestic violence third, which is a felony, the status of that, the status of the drug case. But regardless, the court will note that you do have a theft record, sir, and also a record of violence. You were convicted of assault, battery, and/or domestic violence in 2014. You went to jail on that. You do have a retail fraud conviction, second in 2015. You went to prison for retail fraud in 2016. Appears that you also have a domestic violence conviction, second offense in 2016. And it says here, and again, I may be wrong, but I'm just going by the information I have, and your attorney hasn't given me any other information other than what I have in front of me. It's a possession of a controlled substance less than 25 grams in the 16th circuit pending. So that would mean that you have 2 felony matters still pending out there. Go ahead.
Yeah, the 16th circuit, I don't
Yeah,
know why it
he's
says that. You
he's
can't
got a
say
lot
it's
going on.
Pending. I just got a personal bond out of New Baltimore for the felony domestic. I know what I did wrong, and I apologize for wasting sports time and your time. I really do. I went right to the hospital.
I would ask you to
I
stop
don't care.
talking.
I don't even care. Listen. I
Sorry,
don't-
sir, we're not going to talk about
I
the
just want to
case.
apologize.
We're just going to talk about
That's all.
bond.
I really do. I am sorry for what I did. I'll take my punishment. God will give my
Mr.
punishment.
Troy? Mr. Troy?
I just had to do that.
Okay, we're just going to discuss bond. I'm really bond as is, 5,000 cash for surety, all the standard conditions. Counsel both can address that in circuit court, all right? Okay, anything else from the victims in the matter or not?
Nate, I hope you're right.
Any today?
I really do, because I'll be very upset if it's Shane McMahon. Sorry, talking about some nerd stuff. Creep.
That is quite all right. Kind of a slow day for court, isn't it? Is it just
So
me?
far, but I feel like we're about to ramp
Just
up.
1 minute, then we'll take the Wilson matter.
I'm keeping an eye on the divorce thing. They're not back yet.
One thing I've noticed about this, they do a lot of they just talked to this guy, the Smith guy. We couldn't even see him, and he was getting all out of order. The guy inside the little booth here, that's Mr. Wilson. So you really have to pay attention to what's going on in this courtroom, unfortunately.
We're waiting for your attorney, Mr. Wilson, to return. He was on the last case. He'll be in just a minute. Okay, thank you. Going to the breakout room or not? You did go to the breakout. Oh, we have Mr. Bruce here. I'm sorry.
You weren't there last time either.
Mr. Bruce is here. He's zooming in right now, sir. We'll call the case in a minute.
The
Okay, thank
Smith
you.
guy was saying stuff, and the judge is like, the guy's like, I don't care. I'm going to talk.
Okay,
Wow,
let's
look at
call
everybody
the
coming in.
cases of State of Michigan versus Charles Lee Wilson. We have 5 cases that are up today. File 214923SM, pretrial in a no insurance case. File 214312FY, set for preliminary examination, felony charge of possession of methamphetamine.
Oh.
File 211904ST, pretrial driver license, suspended
Shocker.
second offense, operating while intoxicated and unregistered vehicle. File 210513ST, pretrial driving license, suspended first offense. And finally, we have file
Larry Cobb.
0729 FY.
Hey, Larry.
Preliminary examination set in carrying a
Evan
pistol
Lawyer.
with intent. Mr.
Evan
Jones,
Lawyer
is
saw
there
you
for
over on
record?
Chili's live stream. I watched about 5
Justin
minutes.
Jones, Monroe County Prosecutor's Office.
That's counsel.
Ronald Bruce on behalf of Mr. Wilson.
Mr. Wilson, your full name, please, for the record.
Charles Wilson.
You sure you have enough time to talk to your attorney before today's court event?
Hopefully soon.
Yes,
Snoopy.
sir.
Very good. Mr. Bruce, status, please.
Your Honor, in regards to the felony matters, we're asking to waive the exam, get bound over on the 8th.
Let's take care of the felony matters first then. Mr. Wilson, your attorney indicates that you want to give up a right that you have. You do have a right to a preliminary examination, which is a hearing, and we did have that set for today at 2 o'clock. In case you want to give that right up and go over into circuit court, be bound over there for further proceedings. Is that what you want to do, sir?
Yes, sir.
Okay, and file 4312, as well as file 0729, I will read the waiver language to you. I'll ask if you understand it, and then I'll ask for your permission to sign the form, okay, sir?
Yes, sir.
The waiver language reads as follows. It reads, I, the defendant, understand I have a right to employ an attorney. I may request a court-appointed attorney if I'm financially unable to employ one. I have a right to a preliminary examination where it must be shown that a crime was committed and probable cause exists to charge me with that crime.
Triggers me like
I
2 minutes.
voluntarily waive my right to that preliminary examination and understand I will be bound over to circuit court on the charges in the complaint warrant. Sure you understand that language?
Yes,
I
it's
do.
English.
Yes, sir.
Do I have your permission to sign the form giving up your right to have the hearing?
I'll look at
Yes,
that.
you do.
Lisa. I'll double check.
Mr. Bruce, do I have your permission to sign the form as well?
Yes, Judge.
And Mr. Jones, does the prosecutor's office
Oh,
consent
hell
to the
yeah,
waiver?
Carol.
And do I have your permission to sign the form?
Yes, Judge.
If the court
Carol,
has
we don't have to
signed
remind you of the percentage of winnings,
the
right?
waiver form, the matter is now bound over in both cases for an arraignment in circuit court. Which date do you prefer, Mr. Bruce?
The 8th.
The next court date then for Mr. Wilson will be Friday, April 8th, 2022. That will be at 9 o'clock. That's not tomorrow, but it's the following Friday.
Well, glad he
Anything
sorted
else
that
on
out.
the felony matters, Mr. Bruce.
No, thank you, Judge.
Will continue in both of those matters. We do have the 3 misdemeanor
Look at this
matter.
badass cop outside. Well, excuse me, correction officer. Stay up.
Certainly, we can move this date up, but we can set it currently for June 6th at
Got
10:30. Certainly, the matters are dismissed or resolved.
Judge
before
O'Brien, but you
we
know,
can take the matter earlier, but that's the next court.
My
See
client,
what she's got
my
going
client
on.
has agreed to plead no contest to the felonious assault, Your Honor. And in return, we have a sentence agreement, which hopefully the judge will, Your Honor, will concur with, of 1 year in jail and followed by 1 year of probation in this matter. And I assured Mr. Bloom that even if I'm off the case after his sentencing, I would be available to him should he have any questions while he's on probation. Your Honor, if you have a copy of the transcript in front of you, I believe pages 6, the bottom of 16, 17, or page 34 would be enough for a plea, Your Honor.
Okay, just a moment. And then, Mr. Doby, was that an accurate recitation of the offer?
It is.
So then counts 1 and 2 would be dismissed at the time of sentencing, is that correct?
That is correct.
Okay. Would you raise your right hand to be sworn, Mr. Bloom?
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and
Mr.
nothing
Bloom's
but the
hair
truth?
is amazing.
Yes, it is.
Could you please state your name for our record?
Jeffrey Wayne Bloom.
Thank you.
The thud.
Mr. Bloom, did you hear the statements that the attorneys just made?
Yes.
Oh yeah.
Okay, did you
Have I know?
understand them?
Yes, ma'am.
And do you want to enter a plea in accordance with those agreements?
Yes, ma'am.
Have you had sufficient time to consult with Mr. Killawald about what to do here today?
Yes, ma'am.
Okay, I need to advise you, sir, that count 3 Assault with a dangerous weapon or felonious assault is a felony punishable by up to 4 years. And
If I
for
get arrested, I need
and a consecutive
Judge O'Brien to read me the charges. I'll feel so much better after though.
Yeah, it's true. Yeah.
committed in a place of confinement. You need to understand, sir, that even though you would be entering a no contest plea, I would treat you as if you were guilty at the time of sentencing. So, Mr. Summerall, what is
Somebody
the
moving out
rationale
today,
for
or
the no contest?
Somebody hiding a body?
Potential civil liability, Your Honor.
Okay. There are a number of rights that you'd be giving up if you enter this plea. You have a right to a trial by a jury or by the court if all parties agree.
That we feel is
You have the right to be presumed innocent and to have the prosecutor prove you guilty beyond a reasonable doubt.
Yell at somebody, Judge O'Brien.
Have witnesses against
Please.
you appear at a trial and to see, hear, and question those witnesses. You have the right to call witnesses to testify, and you can ask that the court order that witnesses appear for your trial. You have the right to remain silent and not have your silence used against you. And you also have the right to testify if you so desire. But if you enter this plea today, Mr. Bloom, you would give up all of those rights. We would not have a trial, and the prosecutor wouldn't need to prove any of
Get your
these
guesses in on
allegations.
his charges,
You
by the way.
understand all of that, sir?
I only have one question.
Send you a
Want
link.
to pose that to your attorney?
I could just ask you, you said something about a place of confinement. That wasn't involved, correct?
Jeff,
Mr. Killawald.
I don't believe that applies in this case, Your Honor.
Jeffrey.
So Jeffrey, I think we're okay with that.
Well, I'll take the plea. I agree.
Okay. So, at the time of this offense, were you on probation or parole?
No, ma'am.
Are there any potential immigration consequences,
No,
counsel?
ma'am.
That I'm aware of.
No, Your Honor.
Are you doing this of your own free will?
Yes, ma'am.
Has anybody threatened or coerced you to get you to enter this plea today?
No, ma'am.
Has anybody made any promises or inducements other than what was talked about here on the record?
Just the plea agreement.
Okay, counsel.
Pretty
are you
crappy
aware of
day
any
where Trevor's
such
at.
Promises not on the record?
Dark
No,
cloud.
Your Honor.
Okay,
It's better than where Jeffrey's at right now.
so do you understand that by entering a no contest plea, you would be waiving?
Evan
your
Lawyer,
right
welcome.
to make an argument to the Court of Appeals that pleading was.
Tomorrow,
of
6
your own
p.m.
Free will,
Be there.
Yes, ma'am.
and you'd be giving up your right to argue that there were some threats or promises that we didn't talk about.
Yes, ma'am.
And you'd be giving up your right to a direct appeal to the Court of Appeal. So if you wanted to appeal from either your conviction or your sentence, you would have to ask permission from that other court, and we have no way of knowing how they would respond to that.
Yes, ma'am.
And finally, you would be waiving. your
Please
right
get to it. I want to hear his
appeal
charges, and we're going to jump somewhere
have
else.
been
Yeah.
available to you at the conclusion of
We've
the
made it
trial.
this far,
You
though.
won't
We got to
have a
wait.
trial. Understood?
Yes, ma'am.
Maybe.
Anything about that?
I didn't fully understand that, but I think it's okay.
no.
Oh,
Still a
fudge.
step up if there was a problem.
My God.
Okay, well, if you were trying the case, you might be able to appeal saying that there was something wrong with the juror or that the instruction.
Ted Nugent has really let himself go.
Things in the process of the trial. But if you don't have a trial, you don't have those appellate arguments.
Damn it, the
Yeah, I
Nuge.
understand. I have a case in district court that it hasn't been determined.
Uh-huh.
Will that that since it's before this, it won't have any bearing on this, correct?
I cannot give you that legal advice. You'd need to talk with Mr. Killawald about that. I'm
Jeffrey-
only
Jeffrey,
handling this
shut up,
matter.
Jeffrey.
Jeffrey, you're fine. You're fine.
Shut
Don't worry about the 14B district.
Shut up! As long as they're not gonna violate my probation or whatever.
You're not
Would
on
you know?
probation.
Then I have nothing to worry about.
Thank you, yes, I'll take the agreement, thank you.
Okay.
I saw that he was totally untucked too. You're right.
Talked about here today. Do you still want to enter this plea today?
Oh my
Yes.
God.
Okay. So.
Are
there
you
is
sure?
Appropriate rationale for the no contest plea. So turning your attention to June 19th, 2021 in Ypsilanti Township at or near 559 Kennedy Street. 2, count 3, felonious assault or assault with a dangerous weapon. How do you plead?
I plead no contest.
Okay, and I need to review that preliminary exam transcript to establish the factual basis.
So felonious.
Your Honor, if again, I think page 16, bottom of 16.
Right.
And 17, and then on cross-examine page 34, it's pretty evident what happened, Your Honor.
These biscuits. Hey!
I love a good butter biscuit. Sorry, Creed. If I mean, we've heard his feloniousness. If you want to jump over,
Yeah, have we had enough? Okay,
another
good.
detention
We
hearing
tried.
on
I
April
tried to
14th,
get there.
a new
2022
juvenile
at
detention
1
center.
o'clock PM. Okay, he's remanded to the
Oh,
custody
wow.
of the Juvenile Detention Center. Yes, Mr. Padilla.
Judge, as far as the
Okay.
setting goes, these detention hearings were set for the afternoon because we had other juvenile cases. We don't have any other for that day. Would you like it set for the afternoon or morning?
Well, let's set it for the morning if he's in detention.
Okay, sir. At 10 a.m.?
At 10 o'clock?
Yes, sir.
At 10 o'clock in the morning on April the 4th, 2022. Okay, thank you, Mr. Manga. Your excuse, sir. You have enough.
Thank you, Judge. You have a great day.
Yes. Court's going to call case number 51, 9721J in the matter of Jesus Castillo.
Good afternoon, Judge Andre Maldonado on behalf of the juvenile.
Is the state ready?
Your Honor, we are ready on this case. It is a plea at this time, Judge.
I didn't hear you, ma'am. You cut off.
Sorry, it's a plea this morning, Your Honor, or this afternoon, I apologize.
Is it a deferred prosecution or a regular plea?
A regular plea, Judge.
Okay.
Good afternoon, Judge. Aldo Marquez from the Probation Department. And the mother is present currently over there at detention, and she will need an interpreter.
Okay, the mother's name is what?
Jennifer Leon.
I can't hear you, sir. What's the
Jennifer-
name?
Jennifer Leon.
Leon.
Jennifer de Leon?
Not today,
Jennifer
Street
Leon.
Cred.
Leon.
Jennifer
Not today.
Lopez.
Okay. Before I continue with that one, are there any other ones, or just detention hearings?
Yes, Your Honor, I do have a deferred agreement with Mr. Fonseca today.
Okay, let's take that one. Case number 56, J with 36121J in the matter of Juan Martin Hernandez. Is the state ready?
God.
We are
Glad
present
to
on
have
behalf
to
of
read
the state.
that,
We
man.
are ready, Your Honor.
Is juvenile probation ready?
Vanessa Guerrero for juvenile probation.
Okay, for the record, Juan Martin Hernandez is present in the juvenile detention center.
No, Your Honor, he is not in detention.
All right.
I believe, I don't see them on the screen, Your Honor, but I did advise them about hearing and I did provide them with Zoom information.
Mr. Fonseca, do you know? who
Very
your
quickly,
client-
we'll come back to that. I have no idea what's going on here, but I need to know. This is
Violations of state and federal.
There's a bunch of judges.
Statute.
Yeah.
Which was what
With a
Mr. Berger just spent the majority of his
timer,
time discussing.
even.
And
Look
the
at
third
Burger's
violation,
Place.
Tennessee Consumer Protection
Yeah.
Act.
Holy crap.
Again,
Effing
all
lawyer. What do you
that
think of that out?
both the husband
Set up he's
and
got
the
there.
dealership, she sought or is seeking approximately $850,000 in damages, which, as we noted in the brief, is about 17 times the value of that vehicle.
what is this?
Upon once the complaint was filed, the dealership moved to dismiss. under Rule 12.026 for failure to state a claim on all three counts. Plaintiff filed a response, oral argument was heard, and after oral argument, the court entered a detailed and well-reasoned 16-page order explaining its rationale, and Judge Woodruff dismissed all three counts as to the
Coming in
dealership
hot.
prejudice. I was going to discuss the conversion claim first, but I think perhaps given Mr. Berger's argument, I'm going to skip ahead quickly to the unlawful tracking, as it seems that seems to be now the crux of his appellant arguments.
This is 3 judges here
Mm-hmm.
at the moment. This is insane.
I feel like
that is
Ken and Austin are battling back and forth here, and they're on the clock.
Yeah.
That it is a person who intentionally intercepts or endeavors to intercept any wire, oral, or electronic communication has violated the wiretapping statute. But under electronic communication, there is an express exclusion for tracking devices. This is what the court relied upon, and part of the reason it made its decision. And I think it's plain to see, Your Honor, and I disagree with the plaintiff appellant in that no amount of discovery that might take place if this case is remanded is going to change the interpretation of that statute. If this is truly a
Y2J will be here in a minute.
interpretation, as plaintiff is now alleging in his oral argument, no amount of discovery about who intended what is going to change that.
Super high profile, right? With 3 judges. I mean, it's got to be.
$800,000 is a number I heard thrown out a minute ago.
True.
That is undisputed is the dealership. The dealership has always owned this vehicle. The plaintiff has not stated any otherwise. And frankly, that's the reason that his conversion or that her conversion claim also fails. But for purposes of this, the owner of the vehicle was not plaintiff appellant in this case. It was the dealership. But even taking a step further to even get to the point of holding the dealer liable for these actions, the court would have to find not only that the dealer was an agent, or excuse me, that the husband was an agent.
Thank you,
of the
effing lawyer.
dealership, but that he was acting in furtherance of the dealership's interest. And I think that's a very important distinction, because while there's some vague allegations in the complaint that the husband was a member of the dealership, there are no allegations of the complaint that any of his actions were in furtherance of any business on behalf of the dealership. And Your Honors, he talks about, or plaintiff mentioned this quid pro quo relationship. Respectfully, I'm not sure what quid pro quo is even here. What the dealership gains or stands to gain from some sort of relationship by which the wife of one of its members is given a vehicle for free with unlimited use, with, as the complaint says, no restrictions at all on insurance or use or of any kind, where she is essentially free to use it. There's no duration on it. I'm not sure what quid pro quo relationship existed at all. But even more, to skip back to the point of the unlawful tracking issue, there is a statute under Tennessee and federal law that deals with a tracking device. And I submit that is why it's excluded from the wiretapping statute. And as the trial court correctly found, it is a criminal penal statute. There are no civil remedies in that statute for violations of that. And so even if the court finds that the plaintiff was a lessee, which I submit and we will talk about in just a moment, she was not, and there is not sufficient evidence to show she was. Even if the dealership is found to then be, or that the husband is then found to be an agent of the dealership, which the court would still have to find, which is not clearly pled in the complaint, it is a criminal statute. And that's what the trial court found. There is no civil remedy. There is no civil cause of action for the plaintiff. And so therefore, even taking the complaint on its face is absolutely true, she has still failed to state a basis and state a claim under Rule 12.026. And I believe that the analysis is that simple, Your Honors. Moving to the other claim, which we have argued that the trial court correctly held that plaintiff failed to state a claim for conversion.
Boner.
It is for the very basic reason of what we just spoke about. Plaintiff has no ownership rights in this vehicle.
in order to
think so.
sustain a claim for
Maybe them
conversion,
coming after
she
her
must show
for the money.
appropriation of another's property to one's own use and benefit, the intentional exercise of dominion over the property, and 3, and the most important, in defiance of the true owner's rights. And that's what the trial court correctly held, that based on the facts of the complaint alone, she is not an owner. She never was an owner. At very best.
So did somebody give her a car?
She had possessory rights, which are inferior.
I'm guessing then something happened to this vehicle, so they're looking for money. If it was, did they say they said 800,000, right?
It was just 17 times the value of the car, they said.
States that a conversion is any assumption of control over property that is inconsistent with the rights of the owner. A conversion may consist of use and enjoyment of personal property of another without the owner's consent, destruction or dominion over the property of another by excluding or defying
Wow.
the owner's right, or withholding of personal property from the owner under a claim of title inconsistent with the owner's claim of title. And that, Your Honors, is what the trial court held, that if you,
What's
that
that
if you look
painting
at the face of the
on
complaint,
the judge's?
plaintiff is always alleged she was never.
Everybody's
an
been
owner of
talking
this
about it
vehicle.
in the
And to sustain a claim for
chat.
conversion,
Where you been?
she must articulate.
I was over here trying to
and
find
prove
something.
that she was the owner and had ownership rights in the vehicle. At very best, she has claimed that she has possessory rights, but I submit, Your Honors, that even that is fundamentally flawed. She has claimed that she has an oral lease, if anything, in the vehicle, but the Tennessee courts are clear that in order to have an oral enforceable agreement, there must demonstrate the terms are sufficiently definite to be enforceable. And to the quite contrary, in the complaint, she has stated there was no written agreement, the term was indefinite, there were no conditions of use, there were no restrictions, there
Right.
were no compliance for insurance, there were no forms
Maybe.
for her to sign. Your Honor, these are, in fact, if anyone has ever leased a vehicle, these are the types of
I think
key
so.
provisions of a contract that have to be articulated. And by the very face of the complaint, none of these conditions were ever articulated to her, or if they were articulated at all, again, taking the face of the complaint is true. And so therefore, she has not even stated a plausible claim that she had an oral lease to this vehicle. The same can be said with a bailment relationship. If anything, she had a gratuitous bailment because, again, the dealership received no benefit from the plaintiff having unfettered and unpaid use for this vehicle. And if you take the plaintiff's allegations as true, she, in July, when she was asked to sign this agreement, or if she didn't sign the agreement, she would have to return the vehicle. She extinguished her bailment rights. At that point, she had no possessory rights to the vehicle because she refused to sign the agreement. At that point, even if we take the plaintiff as true, and we do allege that and he do take him at his best and say somehow that the husband was in fact speaking for the dealership, which again is not alleged in the complaint, her bailment rights were then extinguished. And when the vehicle was taken from her, that the dealership or the husband had superior rights at that point. And therefore, she has no superior ownership rights. Again, without those ownership rights, she cannot state a claim for conversion. And that's exactly what the trial court correctly held in this case.
Thank you,
Your Honor,
Ashley
I do
Schaefer,
have
BMW.
TCPA claims. Plaintiff alleged 3 sections of the TCPA, subsections 12, 14, and 21, that she alleged
Judge Kim
that
is
the
starting to
husband
go
and
up.
the dealership
I'll let you know
violated.
later live.
The court found it correctly held that this was not a consumer transaction. It cited to Purcell versus First American National Bank, a 1996 Tennessee Supreme Court decision, which held repossession is not a consumer transaction. It also cited to, and we cited to Davenport v. Bates, Tennessee Court of Appeals 2006, where this court expressly refused to extend TCPA to repossessions. Again, Your Honors, this is, if you look at the gravamen of the complaint, this is a repossession she complains about. This is not a consumer transactions that fall within the.
That's a Nissan dealership.
But even looking to the 3 specific sections she cite, none of
Judge
those.
Porter is on.
Section 12 discusses representations of a consumer transaction that involves certain rights. The complaint makes no allegations of representations or
They
misrepresentations.
haven't said a word.
Section 14 deals with a misunderstanding with respect to the authority of the salesperson to negotiate the final terms. There are no mention of any confusion as to who had
Was she
right to
sleeping with
negotiate
somebody
final
there?
terms in the case alleged in the complaint.
Something
That section's not applicable.
crazy.
And again, section 21, subsection 21 is not applicable, which deals with advertisements.
He's going to
Again,
shut up in a
no
minute and
mention at all
34.
Of advertisements in the complaint.
Take a breath, bud.
And on the very face, your honors, those TCPA claims should fail.
I want to ride this one out just for another minute just to see what happens.
right.
If not, this looks like it could be a long haul, and we'll move on.
That's a no, y'all. No.
Under two theories, both under the TCPA, section 4718-109E, which allows the courts to award reasonable fees if it finds that a TCPA action is frivolous, without legal or factual merit, or brought for the purposes of harassment. And also under the frivolous appeals section 122, and a frivolous appeal has been defined as one devoid of merit or having no reasonable chance of success. Your honors, respectfully, the plaintiff was given every opportunity and was given every inference at the trial court level to state a plausible claim. The trial court delivered a detailed 16-page opinion showing why she failed to deliver such a claim. Furthermore, your honor, frankly, 21 pages of her 26-page appellate brief are copied verbatim from her.
16 pages was 15 pages too long.
Your honor, and
When we left off.
anything as far as maintaining the status quo that as plaintiff alleges to in her brief, that could have been handled at the divorce court level with a contempt motion, not bringing in the dealership. This appears to be gamesmanship with this underlying divorce action that's still pending. So we ask you to affirm the trial court's decision to dismiss the case entirely. Thank you.
Thank you.
Shut
We will hear the rebuttal of the appellant.
Briefly, your honors, every electronic surveillance case.
he gets a minute?
In Appley's brief and in my brief has one thing in common, and that is the emphasis on the expectation of privacy. It makes no difference who owned the computer where the software was improperly applied. It makes no difference who owned the telephone equipment where the tap was applied. And it makes no difference who
tapping people's
owned
phone.
fee simple, if I could use that description.
They were
the
saying something
vehicle
about
on
that.
which the tracking device. The court's ruling on this wiretap issue is narrow as can be. He says, as
I'm
the
on it.
appellee argued,
I got it
and
pulled
is-
up.
is not mentioning today, not emphasizing today, that
Actually, let me give you that, Mikey.
3117, subsection 3117 says there is no wiretap remedy under these facts alleged in the complaint. And respectfully, that is flatly wrong. There's no case law that supports that. It is an interpretive conclusion. My time's up. Thank you.
God, with 2 seconds to
Thank you,
spare.
gentlemen.
What a nice
We
guy
will
Ken
endeavor
Berger
to
is.
get you an opinion at the earliest possible time. We'll take this matter under advisement.
That's
We
it.
appreciate you participating with us via Zoom.
Damn, that was some interesting stuff. See, now,
I will continue to
I
order
wouldn't
this
mind
with the
watching
same.
that
Thank you,
whole
sir.
damn thing.
Yes, sir.
A lot of legal jargon going on there. I was a little lost. I'm not gonna lie.
Yeah, that one was some pretty.
Alexander, are you Alexander?
Yes, sir.
Alexander,
In
my
the
name is
H-pod.
Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney. And I do not believe your attorney, Key Ables, could be here this afternoon.
Watch one of these, and then we're going
I'm
to jump
gonna
over
ask
to the
Trent
divorce.
Lofton,
and, see
another
what's up with
attorney
that.
who regularly represents kids in our court, to step in for Ms. Ables. Good afternoon, Mr. Lofton. How are you?
Good afternoon, Your Honor. How may I ask are you?
Better than I deserve. Thank you for asking. All right. Alexander, the court has previously found that probable cause exists to believe that you may have engaged in delinquent conduct. In fact, I think the last time that we talked,
Trent, quiet,
I told
Trent.
you that if you maintain level 1-0 for the following 12 days, that I would let you go home. In that time, you fell to level 3 confined, so the clock had to start all over. I'm going to continue to make that offer to you. You maintain level 1 outstanding for 12 consecutive days, and you've been there since the 3rd, so you're off to a good start. You got 9 more days. You keep it there, and then I'll authorize your release, okay?
Yes, sir.
You do that for me?
Yes, sir.
Oh.
All right, that'll be the order of the court. I got to keep you here today because you're not there yet, okay?
Okay.
All right, thank
Sarah drinking some cranberry juice.
BRB.
Stephen in a
To Shelby that day.
new spot without the Easter decorations behind him.
Yes, ma'am. Do you have any fault, in your opinion, regarding the trauma that resulted for Shelby that day?
I shouldn't have allowed Stephen to take her without having a signed Rule 11 in my hand. So, yeah, I mean, that's pretty faulty of me that I didn't receive that back from my attorney before I allowed something to happen.
So your testimony, I just want to make sure I understand. Your testimony is that the fault that you had in the traumatic experience and trauma that Shelby endured on September 10th, 2021, is that you didn't get a fully executed Rule 11 agreement before delivering her to Mr. Schneider?
Yes.
Would you say you have any other fault other than your failure to obtain a fully executed Rule 11 agreement?
No.
Okay. Nothing you could have done differently or better? other than not seeking the full execution of the drafted Rule 11 agreement?
Yeah, I just, my fault. I should have known after a decade, don't trust the guy. Hello, this is why we're in this.
She was pretty
Tried to
brutal to
let him read
Stephen last night with her questioning.
I'm going to share my screen. So Ms. Keeney Schneider, I'm going to show you what's been marked as Respondents Exhibit 3 and has already been admitted on the record by agreement of both sides. I'm going to represent to you that these are enrollment forms. They're under a business records affidavit, but enrollment forms for, let me make sure I've got the right one up actually, for River Place Elementary School. Where is River Place Elementary School?
It's not too far within the vicinity of 620.
Okay. Is River Place where you enrolled one of your children in the summer of 2021?
Yes.
Okay. And which kiddo attended or, well, did attend for a short time River Place Elementary?
Sophie Lisbeth.
Okay. And you provided the information that's filled out and given in these forms to the school, correct?
I filled out the information.
Okay. We see here listed a number of contacts for the school to have for the girls, right?
Yes, we've gone over this. Yes, sir.
Okay, but we didn't go over it in front of our Judge Mangrum, did we?
No, I recognize all of this.
Okay. You're listed. Your children are listed. Mr.
Chris
Keeney.
is listed.
If you wait for the full part of my question, ma'am. Mr. Keeney, Maya Touchstone, Mr. I think it's spelled here Bongimno, but I assume that's a reference to Mr. Bongiorno.
Buongiorno.
Should be Bongiorno.
Okay. Some other parties, right?
Correct. Yeah.
Okay. Stephen Schneider's not listed on here at all, is he?
No.
Okay.
No, per the EPL, I wasn't allowed to put him on there.
Objection, ma'am. If you'll just wait for my next question, I'd appreciate it.
I'm sorry.
And looking at further portions of these records, Ms. Keeney Schneider, whose handwriting do we see?
That's my handwriting.
Okay. These are still the forms that you filled out.
Correct.
You agree with me? The date on these forms is July 28th, 2021?
Yes.
All right.
You didn't redact anything on this one, did they?
Again, another portion of the forms dated July 28th, 2021.
Agree.
Yet again, another part of the paperwork dated July 28th, 2021.
Mhm.
Would you agree with me that all of these forms that we see were executed and filled out by you on July 28th, 2021?
Yes.
Do you recall me asking you at your deposition about, let me scratch that actually. You heard the audio recordings that we played earlier when Mr. Schneider was testifying, right?
I'm sorry, one more time. I heard the audios and
You heard the audio recordings that were played during Mr. Schneider's testimony?
I did.
Okay. And you heard your own voice on those recordings, right?
I did.
Okay. And you heard yourself on that recording make statements that Shelby was really having a tough time with the loss of her pappy, her grandfather, right?
So
Yes.
to make an executive
You don't deny
decision,
making that statement.
they're just basically talking about the children. It's just not the fun part. Should we jump out? I mean, we still got a little bit of time.
And
If you want to jump back to Judge Porter, he's on.
Kenny Schneider, I'm going to show you.
Yeah, they're going through a lot of documents. It's
marked as respondents 37.
I said yesterday, if it were as crazy as it was last night, I'd stick with it. If you guys are all right with that, let me know. Jump over to Judge
Yeah,
Porter.
and I work at JPS. I don't know
Yeah.
to put that on him right now, you know. That was a lot, but I don't know if they hire 16-year-olds.
Ms. Wiley, he has been level 1 outstanding for the last 8 consecutive days.
I'm aware, Your Honor.
Do you have any objection to me letting him go home with this excellent mom and dad?
Oh, wow.
Your Honor, I would encourage you to let him go home with his mom and dad.
All right.
JPD Lewis in the
Given
house.
that he's been roaming around at midnight, I am going to require that he be released on the electronic monitor. However, who's Mr. Lewis here?
Yes.
Oh, yeah.
Mr. Lewis.
There he is.
As if Dad wants Ashton to go do some volunteer work at the Presbyterian Night Shelter, I'm going to allow that. Also, once we get a verified work schedule, I'll allow an EM exception for verified work, as well as church. These are good parents and school. So I'm gonna give y'all a little bit more flexibility in working with the parents on EM exceptions than I'd otherwise give, because these parents have been so hands-on.
Yes, sir.
All right, that'll be the order of the court. Thank y'all.
Thank you, Your Honor.
Yay, good parents. A rare thing to see nowadays. Good parents. Well, that's one home.
6 pickles, 1
Yeah,
chicken.
he is.
All right, Diamond, are you Diamond?
Sir.
All right, Diamond, pull your chair a little closer to the computer for me.
Diamond's mama coming up.
There we go.
Mama.
Now I can hear you better. Diamond, my name is Judge Porter. The law says when you're brought into detention and initially detained, you must see a judge every 10 business days thereafter. This is your 10-day hearing. You have the right to remain silent. You also have the right to an attorney, and your attorney, Lateef Adeniji, is here. Good afternoon, Mr. Adeniji. How are you?
Good afternoon, Judge.
All right. Diamond, the court has previously found that probable cause exists to believe that you may have engaged in delinquent conduct, more specifically, the felony offense of assault on a peace officer. Now you're back again on that because you didn't complete your deferred prosecution program.
Saltwater taffy.
Because there was a possible new offense. Are you mom?
Yes.
Have you had a chance to talk with Diamond while she's been in detention?
No,
Okay.
I haven't talked to her in a couple of days. She ain't called me.
Okay.
Talked to her maybe once.
Wow.
When the last time when you called, how'd that conversation go?
It went pretty good.
Well, what does pretty good mean? That's kind of qualified. Tell me what you mean.
Meaning,
She didn't cuss me out,
she
Your
just
Honor.
talked about more getting herself together.
Anything else? Any more specifics?
No.
You're doing a bang up job, Mom.
Well, she's 16, about to turn 17. So what do you think she needs to do to get herself together?
Well, we need to, I think we need like counseling.
No, he does not speak French.
Well, was she offered that while she was on DPP?
Yeah, but we never made it because she ran away.
And when she came back in most recently, she was positive for marijuana. Did you know about that?
No, nobody told me. Sandra didn't tell me.
Well, I get to tell you now. Is it surprising to you?
No.
Why not?
When kids run away, they do things that they normally wouldn't do at home.
How long was she gone when she ran away?
5 months.
Whoa. Did she call you during that time?
One time, she gave me the address. I gave the addresses and phone numbers to Sandra.
So in 5 months, you only heard from your daughter one time.
Yeah, she popped up and I called the police.
Wow. Okay, Diamond, you understand how scary it is to Judge Porter when you're out on the streets for 5 months by yourself? That's really scary for a 16-year-old girl. And it's scary to me, probably to your mom too. Nobody knew where you were. Ms. Perellis didn't know where you were. Your mom didn't know where you were. Judge Porter didn't know where you were.
Where was she?
Did she just say?
All right.
No.
Diamond, you've got a hearing scheduled in front of me next week. We'll see how that goes.
Judge,
Yes, sir, Mr. Adeniji.
I doubt if that hearing will proceed because we are scheduled for psychological evaluation on the 17th. So that's setting. I'm going to talk to Mary, see how we can put it off. Because if we come back, we're coming back for nothing really.
Okay. I'm going to allow you to go ahead and get with Ms. Kelleher, get that rescheduled. Diamond, we'll continue to watch your behavior in the back, but 5 months on the run by yourself without calling mom only one time, never
Major flight
reaching out to Ms. Perellis.
What's that?
That tells me that if I were to release you today, you'd just
flight risk.
cut your monitor off and run
Okay,
again.
yeah.
I can't trust you yet.
She's-
It's going to take longer than 3 days.
So I take it, Judge, I take it that the court is keeping her for our own safety.
Pretty
We
much.
already did the psychuration. We did that last year.
We have to do a new one.
Psychuration?
We have to have one that's
Psychuration.
done within the last 6 months. Does that make sense, Mom?
Yes.
Okay. All right. Well, thank you, everybody. I'm going to keep you here today, Diamond. Sorry.
I guess no surprise there. Listen, this guy, they're in the middle of a divorce thing. This guy apparently broke a bunch of their things as far as their agreement goes, and they were just throwing around some numbers that were pretty high. So let's check in on this. Just see.
On April 1st.
Yes. My client
Good.
says yes.
Yeah, okay, go ahead.
Beginning May 1st of 2022, you will make a monthly payment of $160 toward the $2572.80 each month until that judgment is paid in full. Is that your understanding?
Yes, ma'am. Yes, ma'am.
Okay. Okay. And then as it relates to the $5,625, you're going to, beginning May 1st, make monthly payments of $340 toward the medical support arrears until that amount is paid in full.
Yes, ma'am.
You understand that all of those terms and
30K, right?
conditions
I
will
would
be
not
part
be
of your
laughing.
community supervision, including current child support and current medical support on behalf of your child.
Yes, ma'am.
Is this your agreement?
Yes, ma'am.
Is this what you're asking the court to do?
Yes, ma'am.
Okay, I pass this witness.
Any questions for your client, Michael?
Just briefly.
No, I'm good.
Charlie, you understand that in addition to, just to be clear, you're gonna pay, and I've given you the information. We're gonna try to do an electronic transfer tomorrow. You've got the money in hand to pay the 12,000.
Correct.
And if you get that paid today, that's fine too. I suggest you go ahead and call them. and get that.
12,000 today?
You understand, in addition to that, your regular
Damn.
support amount of $647 and some odd cents plus the $250 also have to be paid during the month
Correct.
of April. Okay. And you understand that the probation is just ensuring that you pay all the amounts that Ms. Rhodes just went over with you.
Okay.
During the terms of those 30 months. Yeah. You understand, if you don't make those payments, then the judge can
You are. It's
find you
contempt of
violating
court, Bob.
probation and issue a warrant. You can be put in jail.
Yeah.
But you're a member.
I'll
You
pass
could be put in jail, Bob, but
All right.
luckily.
But you're a
Jay,
member.
Any other questions? for
That's
your
like
client?
insurance.
I'm sorry for Mr. Pierce.
Just that, I think he said it, but he kind of faded when he said it. Your current child support is still, and your medical support is still due and payable each month, regardless of when you start your payment towards your arrears.
Yes.
Okay. No further
Got
questions.
a lot of
Honor,
rear
Dr.
and
Babineau at this
make up
time?
for, son.
Okay.
Yeah, that's a lot.
Ooh, that's a lot of money.
Ms. Babineau, state your name for the court and for the record.
Marie Alice Babineau.
And Ms. Babineau, have you heard all of the terms and conditions regarding this order for enforcement and contempt that I've just read onto the record and with Charles Pierce?
It's exactly like
Yes,
Zach
I have.
Morris.
And do you understand everything that was recited onto the record?
Yes.
Is this your agreement?
She might be single.
Yes.
we
Are
said.
you asking the court to approve this
She
agreement?
might be.
Yes.
Okay. Ask this witness.
No question.
All right, thank you. All right, if there's nothing else, then the court will find that the court has jurisdiction over the subject matter of the parties. I'll find that the parties have reached an agreement. And I'll approve the agreement, and let's just say motion to enter would be.
Unlike Miss Webster, who still has terrible wood paneling behind her.
Oh, yeah.
May the 2nd.
Is that a piss
8:30?
jug or is that just a lot of
Not
water
sure.
back there?
Sounds
I
good.
don't
George.
know, but that's a lot
right.
of money he's
Anything
got.
else, Shay?
No, just that Miss Babineau is sitting in the law library of South Texas because she's currently in law school.
Really? Don't ask anyone if they know me. Okay. All right. Okay. Well, good. I'm glad, Mr. Pierce, Ms. Babineau, I'm glad you both have worked something out. So, okay. Well, and thanks Shay and Michael for helping out. I mean, working it out too. All right.
Thank
I'll
you,
let-
Judge.
All
Appreciate
right.
it. Thank you, Michael. See y'all later.
Shay,
Sure.
my condolences, Ms. Babineau.
Thank you. Exactly.
Okay, Scott and
Sure did.
Tom. I have
Michael's got a
agreement
great
that
smile on his face for just
and
getting bent over the
you guys
table like
have
that.
The rest of the afternoon. Now,
No
that does
kidding.
not necessarily mean we have to use every minute of this afternoon.
I gotta say,
right.
pretty
Um,
interesting.
ladies,
When you get
out
set
of
up with
abundance of
payments
caution,
like that,
I'm
he's
gonna
like,
keep
"Nah, I
her
dropped
here
12K.
For her
I
own
didn't
safety,
worry."
we're gonna monitor
Yeah, no problem.
her behavior. I know y'all do some superb work. Ms. Brazel, you've got their contact information, is that correct?
Yes, sir.
All right. If you'll begin working with Mr. Let's see, Julie Jacobson and Ms. Brazel, we'll be able to figure out a good solution to
Brazzers.
this issue. All right. So I'm going to keep you here today, Nova. Thank you.
Oh, I didn't see
Nova?
she's
Thank you, ladies.
Oh, okay.
All right.
I just thought
Rodrin, are you
Yes, sir.
Rodrin? My name
Damn
is
it,
Judge
I hope
Porter.
she-
We've met before. The law says when you're brought into detention, you must see a judge within 2 business days. You have the
Looks
right
like
to
a
remain
giant,
silent. You also have the right to an attorney, and we have appointed Trent Lofton to represent you. Good
Now.
afternoon, Mr. Lofton. How are you?
Good afternoon, Your Honor. How are you doing today?
Better than I deserve. All right, Rodrian.
It's good to
The
hear.
purpose of this hearing, as you know, is not a trial. Instead, the purpose of this hearing is to determine whether or not probable cause exists to believe that you may have engaged in some new delinquent conduct.
No.
If in making that determination, the law allows me to consider hearsay evidence in the form of a police report forwarded to me by the Juvenile Probation Department.
real quick. This is what he's talking.
Well,
Man. It's and look, Gabe from The Office. Didn't even know it. But yeah, you see, that's what we're.
School while fighting in school.
no, not fighting
If
this
memory
school.
serves. Yeah, you're on probation out of Judge Terry's court. You got a modification. Well, yeah, modification hearing, plus another hearing scheduled next week in front of her. So I'm going to find that probable cause exists to believe that you may have engaged in delinquent
busy.
conduct. And is Mr. Jennings here? Someone cover?
No, Your Honor, I'm coming from Mr. Jennings.
Mr. Colbert, was this young man given a drug test when he came in yesterday?
That is correct, Your Honor. Yes.
Oh, what were the results of that drug test?
It's positive for marijuana, Your Honor.
Oh, okie dokie. Well,
marijuana.
Seems to me, Rodrian, that if I released you, you would continue to be a danger to yourself by using illegal controlled substances, and I can't let you do that. So I got to keep you here. Thank you, sir.
On the pot.
All right.
There.
I want to thank everybody who's been watching today's hearings. I know they've flown by, but it's important
Trent?
that our citizens keep abreast of what's going on in their governmental institutions.
Talk to me, Trent.
I'll remind everyone who may have been watching on YouTube that recording or rebroadcasting all or part of these hearings is expressly forbidden. Violation of the court's order may subject you to civil and/or criminal contempt proceedings.
Bye, Trent. Going over to lacing.
Whoa,
I think, remember?
Lee.
No,
Haney.
Chamberlain. Permanent.
Lee.
Oh, this is
You had
no.
discussions with the Wizenhunts.
That's
about any sort of
children.
Yes, my lord.
Well,
Pay
I
attention.
mean, it's 1:55 in. If you want to try and jump to something else, or it's up to you.
That's going to be opening by the airport in California, Orange County. So, I mean, I wasn't compensated on that.
Right.
With investment work and capital venture, I mean, not everything's you're raising money for a lot. So, I mean,
Objection, unresponsive.
Sustain.
We looked
And
into that,
so,
JG,
Mr. Schneider,
actually,
we'll
and
move on to a different topic.
it's not the case,
Is
actually.
individual therapy important for your
Thankfully.
daughters right now, in your opinion?
Yes.
Okay, Mr. Schneider has requested on multiple occasions that you reimburse for half of the cost of individual therapy, right?
Right.
Okay. And you have not paid one dime toward the girls' individual therapy, have you?
Uh-oh.
Correct.
And excuse me. To be clear, Mr. Bongiorno also has not paid any cost towards the girls' individual therapy, right?
Bongiorno. What a great name.
Yeah, they were actually.
Schneider, you heard testimony earlier that
They were talking about Bajorno because the name was wrong on one of the
tried
documents.
to see if
Bongiorno.
you're interested in having input about the selection of the girls' individual therapist. Do you recall seeing that?
Yes.
Okay. You would agree with me that you did not reply to that message?
I'm
or
just going to say this now.
ask
Angela from the
message
office is
about
kind
the
of
selection of
C-word
girls'
at me right
therapists?
this minute.
We had a conversation about it.
Okay. So I'm going to show you what's already been admitted as Respondents Exhibit 32, our family wizard
Verbal
messages.
conversation.
If you'll wait for my question, ma'am. Here we see Mr. Schneider reaching out to you and asking for input about using South Austin Counseling Services for their therapy, right?
Mhm.
And we do not see any response
Sarah's phone number
you
was all over the last document.
that follows.
I know Flusher got it.
Has to do with counseling, do we?
Not right here, you don't. Not in your exhibit that you're showing now.
Well, it's a pretty long exhibit. Are
There
you
was some
aware
talk
of any communication
on Steven's side that I was watching yesterday evening, where he was kind of saying that she doesn't have a whole lot of involvement in their therapy, including
That's a
on
big thing now.
Yeah,
That's a big
including on checking in on how things are going, basically.
responded to collaborate about the girls' individual counseling therapists selection?
Yes.
Yeah, they didn't redact
Where
a
is it?
damn thing.
I am unable to go through any documents, data, etc. So I'm not going to speculate on which platform it was on. I have had multiple conversations with Stephen about taking the children to in-network providers. I'm paying for her braces, 50%. Stephen's paying half. Chris is paying half because no orthodontic accepts insurance. So that's really.
I understand. So
I did have a conversation
Ms.
with
Keeney
Stephen
Schneider,
about it.
you need to wait for me to ask a question, please, ma'am. Okay? Please.
I'm going to object to badgering. If it's non-responsive, I'll make the objection. but-
Overruled, Miss Montoya. Miss Keeney Schneider, you do need to listen to the question and answer it. And if there's not a question on the table, you will remain silent until a question is asked. Thank you.
So, Ms. Keeney Schneider, I just want to understand your position is that you should not, neither you nor Mr. Bongiorno should contribute whatsoever at all to the cost of the girls' individual counseling because they're not in-network providers. Is that true? Okay.
It's true.
Okay. You said that you pay half, Mr. Schneider pays half, and Mr. Bongiorno pay half of their braces.
Badgering.
Do you mean that Mr. Schneider pays half and Mr. Bongiorno pays half of those costs?
I mean that Mr. Bongiorno paid half of the deposit for the braces. And each month there's a payment plan. 1 month Stephen will pay for the braces. The other month, Chris will pay for the braces. Every other month we trade off.
Who's Chris?
Okay. Chris,
Yeah, somebody
Mr.
says-
Bongiorno pays for
Who's
your
Chris?
50% share, basically.
Yes.
That's so weird.
Is Chris paying her part for her?
Is she in a poly relationship? I don't know.
You saw what was marked as Petitioner's Exhibit 3. Your, if I understood it right, your property proposal to the court, that spreadsheet. I wanted to ask a few things other than I just want to make sure I understand. I want to put the motor vehicles aside for the moment, okay? And just talk about the other property or debts.
I hope after
Okay,
this
does that make
case
sense?
that John can get him a better
Okay.
little
As
stand over there.
regards everything other than the
I
motor
hope he can get a picture of a train.
Are
to
you
put behind him.
proposing to the court that you keep the accounts, assets, personal property items, debts, liabilities that are in your name right now, and that Mr. Schneider do the same with those same items that are in his name?
Pretty
That's
sure
your
he's
proposal to the court?
living at his mom's.
Okay. And as regards the motor vehicle, Mr. Schneider had testified that he wanted the Yukon, but you are proposing that you be awarded the Yukon. Is that fair?
Yes.
And
Is it a
Mr. Schneider
Denali?
testified that it was, I believe, that it was titled in his father's name and that he and his mother were working on getting that title transferred. Do you recall that testimony?
What's with our cam?
It moves with her.
And his father and Earl Schneider's name? Will you please specify on that?
I see the judge shaking her head, so I may
Wait,
be
which vehicle are you indicating is in Earl's name?
The Yukon.
Well, I may be, ma'am, just wait a moment, okay? I'll get it clear. Hold on 1 second.
Badgering, Your Honor.
You should have seen Keisha going after Steven last night, though. She's pretty badass. So him kind of bringing it, no surprise, you know?
Okay, Steven's last name is Schneider, right?
Yes.
Where's Mr. Bongiorno at?
I don't know. And who the hell is Chris? That's what we need to know. Is who's
Chris
Chris?
is making payments,
When
and
was
Steven's making
the,
payments.
When was the Yukon purchased?
I believe 2012.
Okay. And was that before or after you and Mr. Schneider got married?
It was before
Okay. And who bought it?
my father.
And
My father.
no, I understand. And presently, who?
My mother
does
effing
anyone drive
daddy.
that vehicle right now?
My father does.
Okay. Does he use it
Well-
does he use it as his primary source of transportation?
No, because it's broke down. So
Hmm.
he's not driving it right now.
It's a piece of shit, Your Honor.
So no one's driving the car right now. including your father, right?
No, not really.
Oh no, we tore that car all to hell.
Okay. All right.
God, no Dolphins fan.
And
Nothing to do
Mr.
that.
Schneider mentioned some tools. I believe
It's like that one on 90 Day Fiance that's asking the one girl there with, she's asking for a prenup. Like, what do you have?
Well, she's a nurse. She's an RN. RNs make good money, bud. Or no, she's a nurse
Are
practitioner.
tools in your possession or your
I think.
control that were the property of Mr. Schneider that he used, would you be willing to have those delivered to him and have those awarded to him in this divorce?
I have one bag of tools.
Maybe Chris is, one of the kids'
um,
baby daddies.
I'm not willing
Steven's the other, and then Bajorno's
So no
the new
tools,
dude.
including the bag of tools.
Maybe.
You
Yeah,
are
it's just
to
one
let-
bag of tools that I
Ma'am?
have.
I don't know about a bag
Sorry.
of tools, but she's definitely got a bag of dicks.
So
Me too,
you're not-
man.
you are not willing to let Mr. Schneider have
Such a
any
good grade.
tools in your possession that may have previously belonged to him. Fair?
Fair.
Okay.
And still does, Lisa.
Whose name is on the title for the Equinox?
Uh-oh.
Sarah Elise Keeney Schneider and Ronald Clark Keeney.
Okay. And your attorney mentioned
Why do you have names
that
in your
you were
like,
asking for some
dads?
portion of your attorney's fees to be reimbursed
Somebody's got bad credit. Cream.
by Mr. Schneider. Did I understand that right?
Yeah.
And how much of your attorney's fees do you propose that Mr. Schneider should have to reimburse?
All of them.
At this time,
Oh.
since you and my counsel have made an agreement to kind of let this kind of settle over the next few days and decide on it, I'd like the chance to be able to do the same.
No, ma'am.
Okay.
I'm going to ask you right now how much you believe Mr. Schneider should have to reimburse you for your attorney's fees in this case.
$100%.
Okay. And just to be real clear, should he be making that check to you or to Mr. Bongiorno?
Carefully so, Mr. Bongiorno.
Okay.
Whoa.
And the money that Mr. Bongiorno has paid for attorney's fees, is that subject to any kind of promissory note or loan documents between you and Mr. Bongiorno?
No.
God damn it. 100%. Make the
You
check to
understand Mr.
Bajorno.
Schneider's proposal today regarding property involves him assuming 100% responsibility for any medical debts, any debts, period, including his medical debts that he has.
Yes, that one more time. I'm sorry.
You understand that Mr. Schneider's proposal today, as far as property, involves him assuming 100% responsibility for any of his debts, including his medical debts.
No, I was not under that impression.
Would you believe me if I said that was his proposal?
Of course, this is attorney, yes, sir.
Okay. So, thank you. Your Honor, I will pass the witness.
You have the hair of a honest man.
Leah, do you have anything else for this witness? Let me remind you, you have you now have 56 minutes with the 30 that I gave. You had 26 plus 30, so.
Did she must have put some time constraints on because of.
A couple of questions. I don't want to waste the time. though.
Oh, wow.
Okay, and let me just say before you start, Mr. Hennon, we have someone in the waiting room.
Is it Miss Touch? It's probably Miss Touchstone, Your Honor.
It probably is. That is not the name in which they signed in with.
She should go though. Wasn't she out of surgery or something? Or she's in surgery?
Princess is in the waiting room.
Yes.
That's the name in which this person signed in. Now,
bring 'em in.
That's who it is.
Royalty, Your Honor.
Just wanted to alert you
Royalty.
that we do have someone in the waiting room.
Understood, Your Honor. I believe, assuming that is in fact Miss Touchstone, she knows that she may have to wait a little bit before getting called.
I'm not sure. I'm guessing court reporter.
Go ahead, Ms. Montoya.
Every courtroom has a
That's what I was
creepy
saying.
old
I was
lady.
willing to have her come because I thought she was out of surgery, so I'm saying that I'm okay with waiting for her to come in and go. It's just a courtesy. People come out of
Okay,
the-
I appreciate that. Mr. Hennon, let's see if that is indeed. Oh,
Where's
Let's see
at?
Princess.
I think she's left the
Princess.
waiting room. I guess her ears were burning.
She may be doing it to change the name, Your Honor.
The name.
Trying to
Oh, okay.
encourage that indirectly from my end. So
Okay. Well, let's
Sarah,
give it a minute.
Sarah, you're a C word. Yes, you are a C word.
I think that we're going to cut it there. Pretty crazy stuff yesterday, and I see some with today. Sounds like they're not going to get this done for a couple of days, which is pretty crazy. Guys,
we'll hear from Buongiorno.
I don't know. I wouldn't think so.
I would love to hear from Buongiorno.
My God. Guys, make sure to come back 405 East for nice. Is it a triple play Thursday or what do we got today?
It's a double play Thursday.
Okay.
But there's a Hellcat chasing there, Credence, out of I think Michigan.
904 horsepower.
Gee,
Around
you
there.
best believe it, brother.
Guys, we'll be back for Friday edition of We
Princess
Got a
is here.
Case tomorrow, 1:00 East. Up next, we'll have We Got a Chase, so come back and join us for that. Appreciate you hanging out with us today. Kind of a weird day in court today. I don't know why. Is
Hey,
Thursday
that's
gonna
all
be that
right.
way?
That's all right, because tomorrow's Friday. And we know what Friday means. Harassment court.
Oh, yeah, my favorite day. So we'll see you back here 1:00 tomorrow for We Got a Case. Be doing some gambling later, 6-ish possibly. Keep an eye out for that. And I think that's it.
Yeah. Like it, love it. You know you want some more of it. Until next time, please remember.
These biscuits.